Yeah, a very good afternoon to one and all joined for ADR training session day 1. I quote, peace is not absence of conflict. It is ability to handle conflict by peaceful means by Ronald Reagan. A heartily welcome to one and all for this online ADR session. Now I would like to welcome our trainers for this session. I welcome Sri S.N. Prashanth Chandra, Advocate, High Court of Karnataka and Editor Vakeela Vaahini. Welcome you, sir. Now I welcome Dr. D.M. Hegde, Advocate, High Court of Karnataka. Sir is also serving as CEO and publisher to Vakeela Vaahini. Welcome you, sir. Now I welcome Sri Trivikram, Advocate, High Court of Karnataka. Welcome you, sir, for this session. I welcome our management, Soundarya Educational Trust, our beloved principal, Dr. B.P. Mahesha, Soundarya College of Law, faculty members and students and all the participants for this training session. Dear participants, for better learning experience, please mute your audio and video. Any queries, please post on it in the chat box. Thank you, and over to you, sir.
Thank you, the CEO and management of Soundarya institutions, and particularly Soundarya College of Law. This is a 1.5 days, probably 9-hour session on ADR. So at the outset, I thank the organizers, namely Soundarya and particularly Dr. Mahesh, for having given this opportunity to share our thoughts with you, the young lawyers of tomorrow. In this regard, we will be starting the session now. We'll be introducing you to the different courts in India, followed by how a judicial system works. Then we have as to what are the alternatives, the various alternatives, namely the ADRs, alternative dispute redressal mechanism, followed by the different alternatives, namely arbitration, Lok Adalat, permanent Lok Adalat, conciliation, mediation. We also have one more session on Commercial Courts Act, which is a new concept. That is for today and tomorrow. Tomorrow we have a live session with all of us coming physically to the auditorium of Soundarya at the institution. Today it's only an online session because we all have it's a working day and a court working day also. Tomorrow we also end, and before we end, we have another session where we have live interaction, where we want all the youngsters to join, apply your mind, try to understand what is this concept we are discussing. Any concept just discussed is not enough unless it is understood and implemented. So we'll try to give you a live session with some role play exercises where we want you to share your thoughts, ask yourself the questions and get the answers. I, on behalf of Vakeela Vaahini and on behalf of Dr. Hegde, my friend, and Trivikram, we will be the 3 resourceful persons. Anytime, any question on the subject of law, on the subject of ADR, you are free to ask. I also request all of you to please open your cameras, because unless you open your cameras, we will not know what exactly is running in your mind. So therefore, I request all of you to participate. Anytime you can interrupt and say, sir, I have not understood this, either Kannada, English, whichever language you want to. The whole idea is to see that you understand it, you practice it. Tomorrow, when you're going to be the lawyers, you need to know the nuances of law. At this stage, I also welcome my good friend Ramakrishna HL, a very dynamic personality, who is the PRO of Vakeela Vaahini. He is also with us, very enthusiastic. He has probably seen more advocates than any one of us in his life, and he knows how litigations happen, how litigations emerge. And his presence is also there. I welcome you, sir, Mr. Ramakrishna. You're muted. Thank you. So shall we begin? Mr. Hegde, you will be going through the hierarchy of courts.
Thank you, sir. Thank you.
Thank you, Mr. Ramakrishna. Welcome. Yes, sir. So we will start with Mr. Dr. Hegde, who will take the first few minutes to introduce you as to what are the courts, 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 civil, criminal, all that he will explain in the next 10 minutes. Just listen to him. Any questions, please listen to him and you can ask. Every session you can ask. Every time you can ask. There is no need to wait for the session. You can also ask in the end tomorrow. Trivikram, anything you want to add?
Not at the stage, sir. Thank you.
Okay, thank you. Okay, sir. I need the screen sharing. May I request Dr. Mahesh, please provide me the screen sharing.
Sir, it's enabled, sir. You can share the screen. Thank you.
Okay, okay, thank you. Dr. Hegde.
Yes, sir. Thank you. Thank you, Mr. Prashanth Chandra, sir. And Trivikram, sir. Ramakrishna, sir. And Dr. BP Mahesh. And lecturers and students of Soundarya College of Law. Let us begin our program like this. So, dear friends, let me start hierarchy of Indian courts. As you know, there are many courts. Am I audible?
Yes, yes. If you proceed, I'll
audible?
do the screen sharing. You're audible. Please
Yeah,
proceed.
yeah.
I'll do the screen sharing little later, 1 minute later.
Okay, okay. So you can share the screen, I think.
Yes, yes.
So, dear friends, its hierarchy of court means it's like a triangle shape.
You're able to see the screen?
Yeah, I'm able to see the screen.
Okay, proceed.
Yeah. Am I audible to all?
Yes, yes.
Yes. Yes. Yes, sir. Thank you. See, there are two types of courts, civil courts and criminal courts. As you are seeing now, civil courts, civil judge junior division and civil courts, senior divisions. Then comes to district courts. Then comes to High Court, then the Supreme Court. So, in the criminal side, Magistrate Court is the lowest court. Then comes to the Session Court. Then comes to the High Court. Then to the Supreme Court. Supreme Court is the highest appellate court in India. Now, sir, share the second screen, sir. I will explain after seeing the second screen. Yeah, thank you, sir. So, other than from criminal courts to the Supreme Court, civil court to the Supreme Court, there are so many other courts. Have a look on your screen. It is DC Court, and here in Karnataka, Karnataka KAT, Karnataka Administrative Tribunal, and DRT, Debt Tribunal, then Family Court, Labor Court, Work Board, Revenue Courts, Consumer Forums, and Commercial Courts. These are the different types of the courts. Dear friends, let me explain you now about each courts. As I said, there are two types of courts, civil courts and criminal courts. The lowest court is Civil Judge Junior Division, then Civil Judge Senior Division, then District Courts. So, value of the claim. So, which court to approach? If you have this question, value of the claim that decides. In civil side, less than 5 lakhs, it comes to the civil judge junior division. And more than 5 lakhs to any amount, civil judge senior division. Then after these two courts, appeals to district courts. Let me explain with a few examples of cases. Landlord wanting to evict a tenant is a eviction case. Bank asking recovery from the borrower is a recovery suit. Disputes between brothers and sisters about the property is a partition suit. And dear friends, these are all territorial jurisdictions. All the courts works in a territorial jurisdictions. That means one has to file the case in the jurisdiction where the property lies. For example, if the property is in Tumkuru, you have to file the case in Tumkur court. You cannot file the case in Bengaluru courts, and so on. If you have any questions in between, you may kindly ask. And this criminal side, check bounce cases, which comes under Negotiable Instrument Act, Magistrate Court. And traffic offences, it's a Magistrate Court. Murder comes directly to the Session Court or District Court. As you are aware, there are, other than the civil courts and the criminal courts, there are few other courts. As we have seen, DC courts. DC courts means all deals with the revenue matters, khatas and all. KAT, Karnataka Administrative Tribunal. It's government officers. The KAT you can approach if you are in a service. It deals with the service matters of the government employees. DRT, the debt recovery tribunals. The debt recovery tribunals and debt recovery appellate tribunals were established under the Recovery of Debts and Bankruptcy Act 1993 with the specific objective of providing expeditious adjudication and recovery of debts due to banks and financial institutions. And now let us see the family court. As you are all aware, the dispute between husband and wives comes to the family courts. And now the labor court. A labor court is a governmental judiciary body which rules on a labor or employment related matters and disputes. And work board. Work board, it's a code for the Muslims and the Muslim law, and especially for religious and charitable issues. Now, revenue courts. Revenue courts deal with the cases of land revenue in the state. The highest revenue courts in the district is Board of Revenue. And now let's see the consumer forums. Consumer forums are various organizations which were formed as a result of the consumer movement in India to create awareness among the consumers about consumer rights. Governments gave financial assistance to consumer forums. Consumer forums also represent the individual consumers in the consumer courts. Let me take two examples who can approach the consumer courts. Defective goods and defect in services. For example, if you buy a grinder, you buy from the shop and bring it to home and you start to use it. Then you found it is a defective one. Then you return it to the shopkeeper. Then shopkeeper disagreed to exchange it or take it back. Then you can approach the consumer forum. And defective in service. In a life insurance policy, let us take an example. Medical claim is rejected by the insurance company. Then the person, you can go to the court. Then lastly, we are talking about the commercial courts. Commercial courts are established, it's a very new concept in India. They are established in the year 2015. And you are going to know in detail about all these courts in coming sessions. Dear friends, if you have any doubt or any questions about some type of courts or hierarchy of courts, you may kindly ask.
Thank you, Dr. Hegde.
Thank you, Mr. Prashanth Chandra and Dr. Mahesh and all the lecturers and my dear students for this opportunity given to me.
Just a minute. I'm
Yes, sir.
trying to unshare the screen.
Please.
Yes. Any questions on so far? I see 38 participants here in. Any questions and so far, whatever we have covered? Ankit Porwal. Gokul. See, what is that we are trying to say is, probably I'll take it 2 minutes, Dr. Hegde.
Please, sir.
Once upon a time, maybe hundreds and hundreds years back, there used to be one king who is probably selected by the people. He may not be elected, he may be selected by the people. There are certain times when he has to administer. So he used to administer, he used to look after executive work. He used to look after legislative work. He also used to look after judicial work. Any work coming to him, all the three, what we call pillars of our constitution, he used to look after himself all alone. Then slowly as population grew, people's demand grew, expectations increased, he found it too difficult to administer all three by himself. Therefore, he created some more colleagues, juniors to him, and made them as kings in their respective areas. So executive was given to the executives, the government officers, central and state. The legislative was given to the prime minister with a parliament under him. The judiciary was given to the Supreme Court, the Chief Justice of India, and to all his juniors. So that's how it created courts in all areas. Supreme Court is there only in Delhi. It cannot have in all the talukas, district places, because it's a Supreme Court. It cannot be constituted that easily. Therefore, they created different levels of courts and called them as civil judge junior, civil judge senior, district judge, high court judge, Supreme Court judge. But again, the pendency, the filing of cases, the people's right to ask for justice, judgment, it went on increasing. Naturally, they had to do some alternatives also, because broadly divided it into civil and criminal. Sometimes it becomes difficult for a court to deal with that because without the existing cases. Therefore, they thought of forming different courts under different enactments. That's what Hegde ji was saying about divisional deputy commissioner, deputy commissioner having jurisdiction over mutations or tax matters, where there is a tax payable, and it is not paid, who is answerable to pay tax for a private property? Government property does not pay tax because government cannot ask tax from itself. It can only ask from the private people like us. So I own a property. I need to pay tax. If I don't pay tax, there has to be an office to look after that. So that divisional commissioner or revenue officers were created for that purpose. Waqf. Muslims have their own inheritance law. They have their own trust system. They have their own legal system. They bequeath properties. And Waqf al-Alad is called as private waqf, private trust of the Muslims. An individual Muslim, if he has any property which he wants to give it to his family members, then that is Waqf al-Alad, a private trust amongst the Muslims. He may have noble objective. So to administer that, a Waqf board was created. Waqf board is also a civil court exclusively for Muslim properties of the Muslim religion, people. Consumer law. Mr. Hegde gave an example also. We are all consumers. I am sitting before a instrument which is also a consumer item, namely a laptop. I buy a laptop today. I find some defective goods in that. Maybe I'm not able to use the keyboard. I ask for a change of the keyboard. Then if there is a guarantee period, and in the guarantee period there is some loophole, there is a defect, then I'm covered by the guarantee clause. I am entitled to a exchange or a new type laptop in place of my old laptop. In case there is any deficiency where they are not able to do the work, then I am supposed to go before the consumer court because I'm a consumer under the IF law under the Consumer Protection Act. Defective goods. Hegde also gave an example of insurance. We can go on giving any number of such examples. It could be my Airtel phone. With related to that, there could be some deficiency in service. It is called as deficiency in service. It's a service which is rendered for the price which I pay. If there is a deficiency, I can also approach the consumer forum. Like that, there are so many other forums which are there, which take care of all these disputes. The entire idea of the judicial system is approach at the lowest level, try to get justice at the lowest level, broadly categorized as civil and criminal. And now we have variety of other courts which also deal with the same thing in their exclusive jurisdiction, exclusive courts called as revenue courts, consumer courts, debt recovery tribunal. It's a tribunal, again, it's a court. Debt recovery tribunal deals with bank matters. Suppose a person he is a customer of the bank and has not paid the amount. He is due a certain amount for which installment he has not paid. The bank can recover his money by going to the court. Earlier, they used to come to the civil court and file cases. They found that the civil courts are already burdened with pendency. Therefore, they started thinking of a new court that is called as a debt recovery tribunal, DEBT, debt, SALA. 20 lakhs rupees and above, these debt recovery tribunals are having jurisdiction to deal for disposal of their cases. They cannot go to the civil court. Bank, if it is initiating, or a financial institution initiating a case, it has to be in the debt recovery tribunal. So this is about it. Now we will go to the next aspect of it. A civil dispute. A scenario of a civil dispute. How does it emerge? How does it work? What are the things a litigant or a litigant's advocate has to keep in mind when it comes to civil dispute? I have asked my friend Trivikram to give a visualize for the participants to visualize what would be a civil dispute and how it would emerge, how it would proceed, and how it would end. So over to Mr. Trivikram for your views.
Thank you, sir. And firstly, my heartfelt thanks to the management, more particularly to the principal, Dr. Mahesh PP. And my special thanks to both my learned senior colleagues, Prashanth Chandra sir and Dr. DM Hegde sir. And thank you, sir, Hegde sir and Prashanth Chandra sir, for giving a bird's eye view of how this hierarchy of courts works in this country. Now let us go to the next scenario. But before that, I want 2-3 participants. We cannot have this blank screen. This is a workshop. So I would expect more participation from the students. I can go on saying, but ultimately what we expect is this participation from the students. So 1 or 2 students should volunteer, and you should answer to our questions, or you can also post questions so as to make other friends comfortable and make them understand and to get clarity of what we are dealing with. Can I have 2 volunteers who can switch on their videos and who could interact with me? Otherwise, it becomes one-man show. I keep on talking. I keep seeing my own face. We don't want that monotony. Let's have some interactive session. It's a workshop, unlike a lecture session.
Suveta, please open your camera. Suveta.
There's nothing to be afraid of. ಏನು ಹೆದರ್ಕೊಳ್ಳುವಂಥದ್ದು ಏನಿಲ್ಲ.
Sandeep, please open your cameras. It gives us the...
Yes, very good. Anbu, very good.
ಎಲ್ಲರೂ ಓಪನ್ ಮಾಡಿ, ಇಬ್ರಿಗೆ ಅಂತ ಹೇಳಿದವರು ಮಿನಿಮಮ್, ಹಾಗೆ ಅಂತಲ್ಲ ಅವ್ರು ಮಾಡಿ ಅಂತ ನೀವು ಕೂತ್ಕೋಬೇಡಿ.
Very good, Ramya. Yes. Okay, let us not waste time. I would expect more viewers. I want to see your faces also. Tomorrow anyways we would see, but a better thing to see today and have that familiarity. We'll start with Ramya and Anbu. All right. Just tell me, now you have fair idea how the courts have been bifurcated in this country. 2 broad classifications. One is civil court, other one is criminal. For example, somebody is murdered. That murder case will go to sessions court, etc. Hegde sir has told you. In civil courts, what are the different scenarios, or what kind of cases are filed here? Can you just tell me? Gottidre heli, gottilla andre if you can tell me that nange gottilla, no problem.
Sir, family matters, property matters,
Okay.
and will and inherent property problems, custodies,
Custody of
after the
children.
guardianship. Yes, sir.
Ambu,
Yes,
it is
yes,
custody of children, you are saying. Children, makaladu.
Guardianship, sir.
Yes, yes. Go ahead.
After that, property problems and distribute between to that companies and shareholders. That problems are they are dealing, sir.
Yes. Thank you. So these are the wide varieties of cases which are filed before a civil court. So if you, what we call up that case which is filed before the civil court is usually called as a suit. Wrongly, some people say criminal suit. There is no criminal suit. There's a criminal case. Suit itself means a civil litigation, right? Broadly, what Ms. Anbu told, these are the varieties of cases. If you have to put it across in a little more legally groomed sentence, you can say that suit for damages. For example, you are claiming compensation from one person, XYZ person. What you call it as? You call it as a civil suit for damages. And then suit for injunction. There are varieties of injunctions. You would have studied in Indian Contract Act. You would have studied specific relief act. You would have studied, if you have studied CPC, there are provisions. So you know what is injunction. For example, your neighbor is encroaching. Our mane jagana bit nim mane ಸ್ವಲ್ಪ ಅವರು ಆಕ್ರಮಿಸ್ಕೊತಾ ಇದ್ದಾರೆ. What you do? You come to the civil court. You file a suit for injunction. Third variety, declaration. Simple example. You change your name from Anbu to Anita. What you will have to do? You will have to go to a civil court, ask for a declaration. ನನ್ನ ಹೆಸರು ಹಿಂದೆ ಅನ್ಬು ಅಂತಿತ್ತು, ಇನ್ ಮುಂದೆ ನಾನು ಅನಿತಾ ಅಂತ ಪ್ರಪಂಚ ನನ್ನನ್ನು ಆ ರೀತಿ ನನ್ನನ್ನು ಕರಿಬೇಕು. This is for that purpose you go. Declaration can be for anything and everything. I'm just giving you small examples to make you understand about these varieties of suits. Next, specific performance. Most of you would have already studied Indian Contract Act. There are two parties. They would have understood and they would have come to a common conclusion. I want to sell my car. I want to sell my land or site, and other person wants to purchase. One person who wants to purchase has given some money, what is called as consideration. Other person is waiting. There is an agreement which is already done. The person who was supposed to transfer that site has not transferred to the other person, the purchaser. What do? You waited and waited. How long can you wait? So you approach the civil court by filing a suit for specific performance. An eviction suit, very simple. You have a property in your name. You have a building. You have rented it. You had given it for 3 years or 2 years or 11 months, or usually the time duration would be 11 months. And after that period, your tenant is not vacating. What do? You will have to come to court. Of course, you will have to give statutory notice. That's all secondary, but you come to a civil court. And partition, very popular variety of suit. There are 4 brothers. Father had 4 acres. Very simple, common sense or mathematically, 4 sons, 4 acres divided by 4. But we don't do that. If one person wants all 4 acres. So what happens? There is a civil dispute between the brothers and sisters, family members. They also come to the civil courts. So these are some major varieties of cases or civil disputes that we encounter. This is one part of it. Now let's come to the main topic. What is this main topic? Now, for example, we will take a scenario. You give me a scenario, Anbu, or we will ask Mr. Mahesh, VP Mahesh. I'm not sure if they are students or faculty members, but let's make it little interactive. So we will have somebody else also talking along with me.
I'm a student, sir.
Student, please tell me, Mr. Mahesh. So tell me a scenario, one civil dispute problem. You just give me one line, not too much of time.
So something from a personal example, when it comes to partition suit, a father passed away with, had 9 children, but had a property listed out through a will to one of the children. Everybody else filed a suit saying that they also had a share in the partition and created a partition suit.
Okay, we will take similar situation. All right, we will say take one Ramappa. Ramappa is about 60 years now, and he has 3 brothers. Ramappa has 3 brothers, and those 3 brothers are not giving him property. So what should he do? All of you would suggest, being law students, he should go to the court. The problem starts there. Which court to go, what to do, how to initiate it. The best thing is first thing what strikes our mind is we should approach an advocate. The first problem what we encounter is here. How, whom, where? How will I approach an advocate? Whom? There are hundreds and thousands of advocates. You walk into any road, you will find one blackboard, one name, advocate, solicitors, etc., big names. Whether you can directly approach them, and where is the office? So here the consideration would start, how to go about it. Most of us are not privileged. We would not have advocate friends or relatives. So even if we have relatives, we don't want to approach them. First problem, it's a very difficult problem. Or forget about advocates, you have some medical issue. Which doctor to approach, where to go? There are hundreds of clinics which we see, thousands of hospitals. But where do you get good service? All of us, we start thinking from there. Next, that is the first hurdle. And somehow you have ensured that you have got some details, you have approached, you have made a conversation with that advocate. He gives you an appointment to walk into his office. And now the real problem starts. This is where the procedure will come into picture. So you said you have a civil dispute. Ramappa wants to initiate one civil suit. Now he is already 60 years. And apparently he is in Bengaluru city, and his father's property is located in Tumkur. Tumkur is not very far off, about 1.5 hours of drive with and without traffic, 1.5 hours of drive. But at his age, his 2 children are located abroad. His wife is sickly, she is not keeping well. So he has to take care of the entire family, household activities, as well as now he wants to ignite this litigation. All right. This stage, what happens? You have gone, you have narrated your facts to the advocate. Advocate would say that, nodi, nimge cause of action beku. You cause of action ille file madidre, Supreme Court heliro prakara vaja agutte konege. Your case will be dismissed. Case, a civil suit without cause of action would ultimately result in a dismissal. So cause of action ಅಂತಂದ್ರೆ ಏನು? ಅವ್ರ ತಂದೆ ತೀರೋದ್ರು, ಅವಾಗ ನಾವು ಹೋದ್ವಿ, ಮಾತಾಡಿದ್ವಿ, ನನಗೂ ಬರ್ಬೇಕು ಪಾಲ್ ಕೊಡಿ ಅಂತ. We have requested the family members. After all, they are all my own siblings, brothers or sisters, and all of us in our meeting, what we discussed is this share which has to be divided according to the heads, number of heads or number of siblings, but they did not agree. So ಇಲ್ಲಿ ನಂದು ಇದು ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್. ಬಟ್ ಇದಕ್ಕೆ ನೀವು ಒಂದು ಲೀಗಲ್ ನೋಟಿಸ್ ಕೊಟ್ಬಿಡಿ. ಆ ಲೀಗಲ್ ನೋಟಿಸ್ ಕೊಟ್ಟ ಮೇಲಿಂದ ಶುರು ಮಾಡೋಣ ಕೇಸ್ ಅಂತ ಹೇಳಿ. Sometimes there is something called as a statutory notice. I told you, change your name. You go to a civil court. Civil court, first what you do, you will have to give a statutory notice under section 482 of the KMC Act. So this way, Civil Procedure Code also has some statutory notice. For example, if you have to file a case against the government, you will have to give a statutory notice. Under the Transfer of Property Act, I told you, eviction suit. ಮನೆಯಿಂದ ಖಾಲಿ ಮಾಡಿಸ್ತೀರಾ, ನಿಮ್ಮ ಸ್ವಂತ ಮನೆ ಬಾಡಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ, ಅವರು ಬಾಡಿಗೆ ಮನೆಯನ್ನ ಬಿಟ್ಟು ಹೋಗ್ತಾ ಇಲ್ಲ, ಇವರನ್ನ ಖಾಲಿ ಮಾಡಕ್ಕೆ ವಾಟ್ ಯು ಡೂ ಇಸ್ ಯು ಆರ್ ಫೈಲಿಂಗ್ ಅ ಸೂಟ್, ಬಟ್ ದೇರ್ ಯು ವಿಲ್ ಹ್ಯಾವ್ ಟು ಗಿವ್ ಅ ಸ್ಟ್ಯಾಚ್ಯುಟರಿ ನೋಟಿಸ್. ಈ ನೋಟಿಸ್ ಗಳೆಲ್ಲ ಕೊಡುವಷ್ಟೊತ್ತಿಗೆ ಇಷ್ಟ ಆಯ್ತು, ನೀವು ಹೋಗಿದ್ದು ಅಡ್ವೊಕೇಟ್ ನ, ಯು ಅಪ್ರೋಚ್ ದಿ ಅಡ್ವೊಕೇಟ್ ಇನ್ ದ ಮಂತ್ ಆಫ್ ಫೆಬ್ರವರಿ 2022, and today it is almost July. So ಇವತ್ತು ನಾಳೆ ನೀವು ಹೋಗಕ್ಕಾಗಿಲ್ಲ, ಅಡ್ವೊಕೇಟ್ ಬಿಸಿ ಇದ್ರು. By the time you actually go and you try to execute, ಈ ನೋಟಿಸ್ ಕೊಡೋ ಅಷ್ಟೊತ್ತಿಗೆ ಆಯ್ತು, ಆಗಸ್ಟ್ ಆಯ್ತು. All right, August 2022, and you have successfully sent that legal notice from your end through RPAD. RPAD is registered post acknowledgement due. So what you do is you put that in an envelope and give it to the post office. What they do, they deliver it to the concerned person and take his signature and give you an acknowledgement. That is very important. How will you show the court that the service of that legal notice has been completed? You need some proof, because you are in the court of law. For everything we need proof. You cannot orally say that ನಾನು ಹೇಳ್ದೆ, ನಾನು ಕಳಿಸ್ದೆ ಅಂತ. That ಕಾಲ ಎಲ್ಲ ಮುಗಿದೋಗ್ಬಿಟ್ಟಿದೆ. Now for everything you require some piece of proof. So that is called as RPAD. Through RPAD you have sent it. What you are under impression is ಅದು ಹೋಯ್ತು ಅವ್ರಿಗೆ ತಲುಪತ್ತೆ ಅಂತ. ಅವರಿಗೆ ತಲುಪದೇ ಇರೋದಕ್ಕೆ 100 ಕಾರಣ ಇರುತ್ತೆ. If you just look at any of these envelopes, they would have put a seal. It did not reach that person, address he left, the person did not accept it. So many reasons. If at all your legal service is served upon them, you are successful. You are 50%, you are successful. If it does not successfully been served on that person, then again your next problem arises. How to serve that? Sometimes deliberately they will not accept it. When they know that it is a legal notice or a court notice, they would not accept it. It's a normal modus of people who are into litigation. ತಗೊಳ್ಳೋದಿಲ್ಲ, ತಗೊಂಡ್ರೆ ನನಗೆ ಪ್ರಾಬ್ಲಮ್ ಜಾಸ್ತಿ, ತಗೊಳ್ಳದೆ ಆಟ ಆಡ್ಸೋಣ ಸುತ್ಸೋಣ ಅಂತಾನು ಮಾಡ್ತಾರೆ. I'm telling you why I'm highlighting all this is these are the difficulties, practical difficulties that one person or the litigant would face, not the advocate. Advocate ಏನಾಯ್ತು, ಕಳಿಸಿದ್ರು, ನಮ್ ಕೆಲಸ ಮುಗಿತ್ತು, ನಾವು we will be concentrating on some other work. But ultimately the litigant is waiting in anticipation of some positive result. ಆಯ್ತಾ? ಇದು ಎರಡು ಸಿನಾರಿಯೋ ಈಗ. In the first scenario where the legal notice is served upon them. In the second scenario, it is not served. So what is to be done? Now Of course, in the age of technology, we take alternatives. We send it through WhatsApp. We said we we scan that legal notice and we send it to the party. They would see that blue tick also comes. This also happens. You would then take a screenshot of it where you want to produce it before the court. We don't know how authentically or what is the evidentiary value of that. All that we have still not surpassed because it is all in the infancy stage. But we are doing it. ಅಥವಾ ಸೆಕೆಂಡ್ ಟೈಮ್ ಕಳಿಸ್ಬೇಕಾ ಅವ್ರಿಗೆ, ಬೇರೆ ಅಡ್ರೆಸ್ ಕಳಿಸ್ಬೇಕಾ, ಆಲ್ ದಿಸ್ ಇಟ್ಸ್ ಆಲ್ ಅ ಪ್ರಾಬ್ಲಮ್. ಅಂಡ್ ಮೈಂಡ್ ಯು ಪ್ರತಿ ಒಂದು ನಾವು ಆಕ್ಟಿವಿಟಿ ಮಾಡೋ ಅಷ್ಟೊತ್ತಿಗೆ ಒಂದು 3 ತಿಂಗಳು 2 ತಿಂಗಳು ಕಳೆದಿರುತ್ತೆ. That person wants to Ramappa wants to go and meet the lawyer every time. It's not possible. ಇನ್ನೊಂದು ಅಡ್ರೆಸ್ ತಗೊಂಡ್ಬರ್ತೀನಿ ಸರ್ ಹುಡುಕ್ತೀನಿ ಅಂತ ಅವ್ರು ಕೇಳಿ ಅವರ ನೋನ್ ಕಿತ್ ಅಂಡ್ ಕಿನ್ ಹತ್ರ ಎಲ್ಲ ಕೇಳಿ ಕೊಡೋ ಅಷ್ಟೊತ್ತಿಗೆ ಒಂದು 3 ತಿಂಗಳಾಯ್ತು. ಸೊ ಜಸ್ಟ್ ಇಮ್ಯಾಜಿನ್ ಸೆಪ್ಟೆಂಬರ್ ಅಕ್ಟೋಬರ್, ನೀವು ಹೋಗಿದ್ ಫೆಬ್ರವರಿ, 8 ತಿಂಗಳು ಮುಗೀತು. ಇಷ್ಟರಲ್ಲಾಗಿದ್ದೇನು ಒಂದು ಲೀಗಲ್ ನೋಟಿಸ್ ಅಡ್ವೊಕೇಟ್ ಆಫೀಸ್ ಇಂದ ಪಾರ್ಟಿಗೆ ಹೋಯ್ತು, ವಾಪಸ್ ಬಂತು. ಕರೆಕ್ಟ್? ಇಸ್ ದ ಫಸ್ಟ್ ಪ್ರಾಬ್ಲಮ್. ಆ 2 ಸಿನಾರಿಯೋ ಹಂಗೆ ಮೈಂಡ್ ಅಲ್ಲಿ ಇರಲಿ. ಸ್ಟಾಪ್ ಇಟ್ ದೇರ್. ಥರ್ಡ್ ಒನ್, ಇಷ್ಟು ಟೈಮ್ ಇರೋದಿಲ್ಲ ಕೆಲವು ಕೇಸ್ಗಳಲ್ಲಿ. ಅರ್ಜೆನ್ಸಿ. ವಾಟ್ ಈಸ್ ದಟ್ ಅರ್ಜೆನ್ಸಿ? ಸಂಬಡಿ is encroaching your building, your neighbor is encroaching, somebody else is building, constructing one more floor without permission. So there is urgency, grave urgency, and these all lakhs together, close together properties. Can you sit for 8 months, 9 months like Ramappa? There it is a partition suit. ನಿಮ್ ಮನೆನೇ ಹೊಡೆದಾಕ್ಬಿಡ್ತಾರೆ. ನಿಮ್ ಗೊತ್ತಿಲ್ಲ ನಿಮ್ ಸೈಟ್ ಅಂತಂದ್ರೆ ನಿಮ್ ಸೈಟ್ ಅಲ್ಲಿ ಅರ್ಧ ಸೇರಿಸಿ ಕಟ್ಬಿಡ್ತಾರೆ. All this is very rampant. You will encounter this. You go out to some of the cases, ಅವ್ರ ಸೈಟೇ ಅಲ್ಲ ಅದು, ಸುಮ್ನೆ ಹೋಗಿ ಒಂದ್ ಮನೆ ಕಟ್ಬಿಟ್ಟು ಬಿಟ್ಬಿಟ್ಟಿರ್ತಾರೆ. For you to get it demolished, it is next to impossible. So that urgency is not considered here. ಕೆಲವು ಸತಿ ತುಂಬಾ ಕಷ್ಟ. When things are pressing, you want overnight relief. Parties will call and say, sir, ಇವ್ರು ಬಂದ್ಬಿಡ್ತಾ ಇದಾರೆ, ನಾಳೆ ಕೇಸ್ ಫೈಲ್ ಮಾಡ್ಬಿಡಿ. ಬೆಳಗ್ಗೆ ನಾವು ಫೈಲ್ ಮಾಡಿ 3 ಗಂಟೆಗೆ ಬರ್ಸ್ಬಿಟ್ಟು people want relief. But will that happen in reality? Urgency. Dependency. As I told you, Ramappa is 60 years. His 2 sons are abroad. His wife is sickly. He has to travel, and he cannot have a Bangalore lawyer who will appear before the Tumkur court. So he has to have a local lawyer in Tumkur. And for that, he is dependent. 60 years ಅಲ್ಲಿ ಅವರಿಗೆ ಈಸಿಯಾಗಿ ತುಮಕೂರು ಹೋಗಕ್ಕಾಗಲ್ಲ. He might not have a 4-wheeler, or he might not know driving. He is dependable on some other person who has to take him to Tumkur, or he has to take some other transportation. Correct? And just I'm giving you example. I'm not getting too trivial into the subject, but I'm telling you, ಮನೆಯಿಂದ ನೀವು ಮೆಜೆಸ್ಟಿಕ್ ಹೋಗ್ಬೇಕಾದ್ರೆ ಒಂದು ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಬೇಕು. ಅಲ್ಲಿಂದ ನೀವು ತುಮಕೂರು ಬಸ್ ಹತ್ಕೊಂಡು ಹೋಗ್ಬೇಕು. ಅಲ್ಲಿಂದ ಒಂದು ಗಾಡಿ ತಗೊಂಡು ಅಡ್ವೊಕೇಟ್ಸ್ ಆಫೀಸ್ಗೆ ಹೋಗ್ಬೇಕು. And you have to repeat it. ವಾಪಸ್ ಬರ್ಬೇಕಾದ್ರೆ ಮಳೆ ಬಂತು. These are all practical problems. The dependency, not everybody at your age, you can directly take your 2-wheeler, you go to an advocate's office, that happens. But by and large, litigants are not all energetic and young as you people. There are informed people who are in their own varieties of litigants. Next, court fees, very important. For example, somebody you had given 40 lakhs rupees. 40 lakhs was given as a friend. You had lent that money to X person, your friend, for some good reason. Madveno, education go. 15 days ಅಲ್ಲಿ ಕೊಟ್ಬಿಡ್ತೀನಿ, ನನ್ನ ಬ್ಯಾಂಕ್ ಬರುತ್ತೆ, ಲೋನ್ ಮಾಡಿಸಿದೀನಿ. ಇವೆಲ್ಲ ದಿಸ್ ಆರ್ ದಿ ನಾರ್ಮಲ್ way people will ask for money. You are also kind hearted. You want to extend some help. You have given 40 lakhs rupees to your friend. Initially that friendship was evergreen. ಇನ್ನೊಂದು 2 ದಿವಸ ಬಂದ್ಬಿಡ್ತು. This 2 ದಿವಸ will become 2 years. ಏನೂ ಆಗಿಲ್ಲ. Now finally assume that all your statutory notice, everything you have exhausted, you have done all that. Now finally is reluctant, is not ready to pay that 40 lakh rupees even after due service of that legal notice. Now what are you supposed to do? The only alternative is court. Well, if you have to go to court, you will have to pay approximately close to 10%. I'm telling you, it varies. The law says it varies 6%, 5%, 7%. I'm just giving you a vague example. 40 ಲಕ್ಷ ರೂಪಾಯಿ ನೀವು ವಾಪಸ್ ಇಸ್ಕೋಬೇಕು ನಿಮ್ ಫ್ರೆಂಡ್ ಇಂದ ಅಂತ ಕೋರ್ಟ್ಗೆ ನೀವು 4 ಲಕ್ಷ ರೂಪಾಯಿ ಹೆಚ್ಚು ಕಡಿಮೆ ಕೊಡಬೇಕು. ಮೇ ಬಿ 2.5 lakhs. I'm just giving you an example. Plus, in addition to that, you have to pay advocate's fees. ಸುಮ್ಮನೆ ಹೋಗಿ ಕೊಟ್ಬಿಟ್ರೆ ಆಗತ್ತಾ? ಆಗೋದು. You need an advocate. You need a mouthpiece. They're all called as mouthpieces of the litigants. ಸೊ ನಾವು ಅಲ್ಲಿ ಹೋಗಿ ಮಾತಾಡ್ಬೇಕಾದ್ರೆ ನಾನು ಇಲ್ಲಿಂದ ಪೆಟ್ರೋಲ್ ಹಾಕೊಂಡು ಸಿವಿಲ್ ಕೋರ್ಟ್ ವರೆಗೂ ಹೋಗಿ ಸುಮ್ಮನೆ ಹೋಗ್ತೀನ. I have expenses. Who should bear that expense? I'm sorry, ultimately the litigant. So court fees pay ಮಾಡಿ. ಮತ್ತೆ ಇವಾಗ ಹೆಗ್ಡೆ ಸರ್ ಹೈಲೈಟೆಡ್ ಎಲ್ಲಿಗೆ jurisdiction ಎಲ್ಲಿ ಫೈಲ್ ಮಾಡಬೇಕು ಅಂತ. I told you Ramappa is a localite. He is residing in Bangalore city. His property is located in Tumkur. Just because he is located in Bangalore, he cannot file suit here. He has to go to that jurisdictional court. He has to approach that either the senior division or the district or whatever the case might be. He has to go and file a suit in Tumkur courts. So that is one more difficulty. That the case has to be filed there. Then starts with the pleadings. Pleadings is nothing but drafting. Whatever you say or you want to convey to the court, everything is written. So basically drafting, and you also have a paper in your syllabus. What you learn is how to convey what is in your mind and what is the facts and circumstance of the case to the court, and what you are seeking from that court, you put it on black and white in terms of some paper. So this has to be complete. In this regard, till you give it to the court or you give it to the filing counter, if you have made mistakes, you can tear that, you can add one page, you can delete one page, you can scratch, you can put small signature and give. Once that court seal is affixed, you cannot change it. Even if you want to put one small alphabet or you want to put one comma, you will have to take the permission of the court. Then that will go forever and ever. On the more nalak hearing hogutte. What I'm trying to tell you is that all these will happen in practical. These are the practical instances. We are all human beings. We tend to forget. For example, sometimes you come till the vehicle, then you realize you have not bought the keys. Same way, when you have drafted, you would have forgotten to say something which is very important in your pleadings. How do you edit it? You will have to take permission of that court. Everything is time consuming. Next, what is presence of the parties? Yes. Now the next, assume that you have filed, you have approached the lawyer, you have sent the statutory notice or the legal notice, then you have also paid the court fees, then your pleadings are complete, your plaint, what you have given it to the court is perfect, there is no error. Now you should also go and stand before the court. Court would ask plaintiff bandidara ilva. Time most of the cases, for example 138 case, if you have to file a civil suit for recovery, the magistrate or the concerned civil judge would say where is the complainant, where is the plaintiff. Plaintiff's presence is required. Ramappa has to go and stand before the court. Nothing he will do, but his presence is recorded. So again, that repetition from Bangalore, take one cab, go to Majestic, then go to Tumkur, then take that cab again, go to the district court. You can't even, you will not, it's not a building like High Court where you can appreciate building ಎಷ್ಟು ಚೆನ್ನಾಗಿದೆ, at least ಹೋಗಿ ನೋಡ್ಕೊಂಡ್ ಬರೋಣ. ಆರ್ಡಿನರಿ ಕೋರ್ಟ್ ತುಮಕೂರಲ್ಲಿ ಹೋಗ್ಬೇಕು, ಅಲ್ಲಿ ಮಳೆ ಬರ್ತಿರುತ್ತೆ, ಇದ್ರ ಮಧ್ಯೆ ಎಲ್ಲ ಹೋಗು, ಲಾಯರ್ಸ್ ಎಲ್ಲ ನಿಂತಿರ್ತಾರೆ, ಪಾರ್ಟಿಗಳು ನಿಂತಿರ್ತಾರೆ, ಏನೂ ಅರ್ಥ ಆಗಲ್ಲ. ಅಲ್ಲೆಲ್ಲ ಹೋಗಿ ನಿಂತ್ಕೊಂಡು ಕೆಲವು ಸತಿ ಸಮ್ಮರ್ ಅಲ್ಲಿ ಯು ವಿಲ್ ಬಿ ಸ್ವೆಟ್ಟಿಂಗ್, ಯಾವಾಗ ಹೊರಗಡೆ ಬಂದ್ರೆ ಸಾಕೆ ಅಂತ ಆಗಿರುತ್ತೆ. ಆಲ್ ದಿಸ್ ಡಿಫಿಕಲ್ಟಿ ನೀವು ಅಲ್ಲಿ ಪ್ರೆಸೆಂಟ್ ಇರ್ಲೇಬೇಕು. ನೀವು ಪ್ರೆಸೆಂಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಕೇಸು ಅಡ್ಜರ್ನ್ ಆಯ್ತು, ಯು ಲೂಸ್ ಒನ್ ಮೋರ್ ಡೇಟ್. ಇನ್ನೊಂದು 15 ದಿವಸ ಬಿಟ್ಕೊಟ್ರೆ ಜಡ್ಜ್ ಇಸ್ ಜನರಸ್, ಯು ಆರ್ ಲಕ್ಕಿ, 3 ತಿಂಗಳು ಬಿಟ್ಕೊಡ್ತಾರೆ ಕೆಲವು ಸತಿ, ಬಿಕಾಸ್ ದೇ ಹ್ಯಾವ್ ಸೋ ಮೆನಿ ಪೆಂಡೆನ್ಸೀಸ್. ಐ ಆಮ್ ನಾಟ್ ಮೇಕಿಂಗ್ ಅಲಿಗೇಷನ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಜಡ್ಜ್, ದೇ ಆರ್ ಆಲ್ಸೋ ಓವರ್ ಬರ್ಡನ್. ಇನ್ ಅ ಸಿಟಿ ಲೈಕ್ ತುಮಕೂರ್, ದೇ ಡೋಂಟ್ ಹ್ಯಾವ್ ಸೋ ಮೆನಿ ಜಡ್ಜಸ್. ಹೌ ಕ್ಯಾನ್ ದೇ ಅಕಾಮಡೇಟ್ ಯು? ಓಕೆ, ಕೊಡ್ತೀನಿ ಡೇಟ್ ತಾನೇ, ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ, 1-3 ತಿಂಗಳು ಬಿಟ್ಕೊಡ್ತಾರೆ. ಏನ್ ಯು ವಿಲ್ ಹ್ಯಾವ್ ಟು ಗೋ ರಿಪೀಟ್ ದ ಸೇಮ್. ಇಫ್ ಯು ಆರ್ ಲಕ್ಕಿ, ಓಕೆ, ನೋಟಿಸ್ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರು, ನೋಟಿಸ್ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ ದಿಸ್ ನೋಟಿಸ್ ಹ್ಯಾಸ್ ಟು ಗೋ ಟು ದಿ party, defendant or defendants. And again, I told you, these are the same problems. When you have sent that through post, the court also will do. There are 2 options. Either One is send it through RPAD and second one is through court. Court ಅಲ್ಲಿ court ಒಬ್ರು ಇರ್ತಾರೆ, ಅವರು ಇದನ್ನ ತಗೊಂಡು ಹೋಗಿ ಸರ್ವ್ ಮಾಡಿ ಕೊಡ್ತಾರೆ. Litigants are very intelligent. They know how to evade the service of the summons. So they take all ways and means to evade it. And sometimes, of course, the address will be wrong. And in places like Tumkur, there is no building number, there is no lane, there is no stage, there is no layout. ಸುಮ್ನೆ ಒಂದು ಹಾಕ್ಬಿಟ್ಟಿರ್ತಾರೆ, ತ್ರಿವೇಣಿ ರೋಡ್ ತುಮಕೂರು, ಅಲ್ಲಿ ಯಾರು ರಾಮಪ್ಪ ಯಾರು ಹನುಮಪ್ಪ ಯಾರಿಗೂ ಗೊತ್ತಿಲ್ಲ. ಆಯ್ತಾ, ಅಲ್ಲಿ ಹನುಮಪ್ಪ 4 ಜನ ಇದ್ದಾರೆ, ಅಲ್ಲಿ ಏನೋ ಸನ್ ಆಫ್ ಅಂತ ಹಾಕಿದ್ರೆ ಅದು ಸ್ವಲ್ಪ ಏನೋ ಹೆಲ್ಪ್ ಆಗ್ಬೋದು, ಅವ್ರ ಮಗ ಅಂತ ಕೇಳ್ಕೊಂಡು ಹೋಗ್ತಾರೆ. ಅದರ್ವೈಸ್ ಇಟ್ ವಿಲ್ ಕಮ್ ಬ್ಯಾಕ್ ಟು ಕೋರ್ಟ್, ನಾಟ್ ಸರ್ವ್ಡ್ ಅಂತ ಕೊಡ್ತಾರೆ ಶರ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ನೀವು ಫೈಲಿಂಗ್ ಮಾಡಿದ್ದಲ್ಲಿ ಫೆಬ್ರವರಿಯಿಂದ ಬಂದು ಲಾಯರ್ ಆಫೀಸ್ ಹೋಗಿ ಅಕ್ಟೋಬರ್ ಆಯ್ತು, ಅಕ್ಟೋಬರ್ ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಒಂದು ಡೇಟ್ ಅಂತ ಕೊಟ್ಟರು, ನೋಟಿಸ್ ಮಾಡಿದ್ದಾರೆ ಕೋರ್ಟ್, ನೀವು ಹಾಕಿರುವಂತ ಕೇಸ್ ಬಗ್ಗೆ ಮಾಹಿತಿನ ಕೊಡಕ್ಕೆ, ಟು ಗಿವ್ ಇಂಟಿಮೇಷನ್ ಅಬೌಟ್ ದಿ ಕೇಸ್ ದಟ್ ಯು ಹ್ಯಾವ್ ಫೈಲ್ಡ್. Summons or notice is issued by the court which should reach the defendants. Now I am mentioning you there are 2 or 3 defendants in this case, 3 ಜನಕ್ಕೂ ಸರ್ವ್ ಆಗಿಲ್ಲ. So this date, from the date of service, ನೀವು ಕೇಸ್ ಫೈಲ್ ಮಾಡಿದ ದಿವಸ ನೋಟಿಸ್ ಮಾಡಿದ ಯಾವತ್ತು ಅಕ್ಟೋಬರ್ 31st, ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಬಂದು 28/2 ಅಂದ್ರೆ ಫೆಬ್ರವರಿ 2023ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೊ ಈ 3-4 ತಿಂಗಳಲ್ಲಿ ಏನಾಗ್ಬೇಕು, ಆ ಸಮನ್ಸ್ ನೋಟಿಸ್ ಹೋಗಿ ಅವರಿಗೆ ತಲುಪಿ, ಆ ಶರ ಇರುತ್ತಲ್ಲ ಅವ್ರು ತಗೊಂಡು ಸ್ವೀಕಾರ ಮಾಡಿದೀವಿ ಅಂತ ಸೈನ್ ಹಾಕಿ ಕೊಟ್ಟಿರೋದನ್ನ ಕೋರ್ಟ್ ತಗೊಂಡ್ ಬಂದು ನೆಕ್ಸ್ಟ್ ಅವ್ರ ಲಾಯರ್ ಮುಖಾಂತರ ಬರ್ತಾರೋ ಅವ್ರು ಬರ್ತಾರೋ, ದಟ್ ಇಸ್ ಆಲ್ ಲೆಫ್ಟ್ ದಿ ಡಿಸ್ಕ್ರಿಷನ್ ಆಫ್ ದಿ ಪಾರ್ಟೀಸ್. ಇಲ್ಲಿ ಇಟ್ ಇಸ್ ನಾಟ್ ಸರ್ವ್ಡ್ ಇನ್ ಅವರ್ ಕೇಸ್. ಸೊ ಫೆಬ್ರವರಿ 2023 ವಾಟ್ ಶುಡ್ ಯು ಡೂ? ರೀಇಶ್ಯೂ. ಮತ್ತೆ ಅದನ್ನೇ ರಿಪೀಟ್ ಮಾಡಿ ಇನ್ನೊಂದು 3 ತಿಂಗಳು ಕೊಡ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ವುಡ್ ಬಿ ಸೇ ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ವೆಕೇಶನ್ ಮುಂಚೆ ಅಂತ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ, ವೆಕೇಶನ್ ಸೇ 15th of April. Second time also it is not served, and it is served on one defendant. So what is to be done now? Reissue to other 2 defendants. ಸುಮ್ನೆ ಹೋಗಿರ್ತಾರೆ, ವಕಾಲತ್ ಹಾಕಿರ್ತಾರೆ, ಅಲ್ಲಿ ಏನೂ ಆಗೋದಿಲ್ಲ, ಇಬ್ರಿಗೂ ಸರ್ವ್ ಆಗ್ಬೇಕು. ಅವ್ರಿಗೆ ಇನ್ನ 3-4 ತಿಂಗಳು ಕೊಟ್ಟರು ಆಗ್ತಾ ಇಲ್ಲ, then you have to go for substituted services. ಬೇರೆ ಕೆಲವು ಸತಿ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಂತ ತಗೋತೀವಿ, ಕೆಲವು ಸತಿ ಪೊಲೀಸ್ ಮುಖಾಂತರ ಕಮಿಷನರ್ ಆಫ್ ಪೊಲೀಸ್ ಮುಖಾಂತರ ಕೋರ್ಟ್ ಕೊಡ್ಬೋದು. ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಯಾವುದು ಆಗಿಲ್ಲ, ಪೇಪರ್ ಅಲ್ಲಿ ಪಬ್ಲಿಷ್ ಮಾಡ್ತಾರೆ. ಸೊ ಇದೆಲ್ಲ ಮಾಡೋ ಅಷ್ಟೊತ್ತಿಗೆ ಡಿಸೆಂಬರ್ 2023 ಆಯ್ತು. Now your case is filed, notice has been served on one defendant, 2 more defendants have not come to the court because they are not aware that summons or notice has not been served upon them. Now we have taken a paper publication. It's not an easy task. Paper ಅಲ್ಲಿ ಹಾಕ್ಸೋದು ಅಂತಂದ್ರೆ ಅದು ಖರ್ಚು, 4,000 ಇಂದ 10,000 ಖರ್ಚಾಗುತ್ತೆ. What I am telling you is some vague amount, but more or less it is like that, ಅಷ್ಟು ಬಂದೇ ಬರುತ್ತೆ. So that is one more problem. ಅಲ್ಲಿ ದುಡ್ಡು ಕಟ್ಟಿದ ಮೇಲೆ ಅದು ಹೋಗಿ ಅದಕ್ಕೆ ಒಂದಷ್ಟು ಸತಿ ಅದಕ್ಕೆ ಕ್ರೈಟೀರಿಯಾ ಇರುತ್ತೆ, at least 3 times you should have gone and come back. All these criteria you have fulfilled, you have also published in the paper. Now the case should start. And what happens? That plaintiff dies. Case ಯಾರು ಫೈಲ್ ಮಾಡಿದ್ರು ಅವ್ರು ಸತ್ತೋದ್ರು. Who should take care of that case? The legal heirs. So there is some time period fixed. ಅವರು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಆಗಿ ಲೀಗಲ್ ಹೇರ್ಸ್ ನಾವು ವಿ ವಿಲ್ ಕಮ್ ಆನ್ ರೆಕಾರ್ಡ್ ಅಂತ ಕೋರ್ಟ್ ಮೆನ್ಷನ್ ಮಾಡಿ, ದೇ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಕಮ್ ಆನ್ ರೆಕಾರ್ಡ್ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ದಿ ಪ್ಲೇಂಟಿಫ್. ದಟ್ ವೈಫ್ ಆರ್ ಚಿಲ್ಡ್ರನ್ ವುಡ್ ಸ್ಟಾರ್ಟ್ ಪ್ರಾಸಿಕ್ಯೂಟಿಂಗ್ ದಟ್ ಕೇಸ್. ಸೊ ಇದೆಲ್ಲ ಆಯ್ತು. ಜಸ್ಟ್ ಅಸ್ಯೂಮ್ ದಟ್ ಆಲ್ ದಿಸ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್ಡ್ ಅಂಡ್ ನೌ ದ ಕೇಸ್ ಸ್ಟಾರ್ಟ್ಸ್ ಅಂಡ್ ಸಮ್ ಡಿಫೆಂಡೆಂಟ್ ಡೈಸ್. ದ ಸೇಮ್ ಥಿಂಗ್ ಹ್ಯಾಸ್ ಟು ಬಿ ರಿಪೀಟೆಡ್. ಇವೆಲ್ಲ ಮುಗಿಸ್ಬಿಟ್ಟು issues, there are several procedures which are prescribed by the civil procedure. So now after the due service of summons and notice, etc., the court should frame issues. What are issues and all we will not touch here because you have CPC, you will be studying that subject and you will understand. CPC issues idella frame madadmele evidence barutte. Just assume that all this will conclude by 2024 or 25 if you are lucky enough. Partition suits which were filed when I was in 10th standard, it is also pending today before the same court. It has not even gone to the next level of hierarchical court. It is in the same court. Stage ಏನೋ ಒಂದು ಸ್ವಲ್ಪ ಆ ಕಡೆ ಈ ಕಡೆ, ಅಲ್ಲಿ ಪ್ಲೇಂಟ್ ಗಿಂತ ದಪ್ಪ ಆಗಿರೋದು ಆರ್ಡರ್ ಶೀಟ್. ಪ್ರತಿ ಸತಿ ಜಡ್ಜ್ ಬರ್ದು ಆ ಆರ್ಡರ್ ಶೀಟ್ ಒಂದು ಇಷ್ಟು ದಪ್ಪ ಆಗ್ಬಿಡುತ್ತೆ. I'm just telling you, 24 suppose you are lucky that case got disposed and decree is passed in favor of the plaintiff. What the defendants will do? Defendants will prefer an appeal. ನಮಗೆ ಇದು ಸರಿ ಇಲ್ಲ, ಇದರಲ್ಲಿ ತಪ್ಪಿದೆ, ನಮ್ಮ ಪರ ಬಂದಿಲ್ಲ, ನ್ಯಾಯ ಬೇಕು ನಮ್ಗೆ, ನೆಕ್ಸ್ಟ್ ಕೋರ್ಟ್ ಹೋಗ್ತಾರೆ. ಅಪೀಲ್ ಇಸ್ ಅ ಸ್ಟ್ಯಾಟ್ಯುಟರಿ ರೈಟ್. ಯು ಕಾಂಟ್ ಸ್ಟಾಪ್ ದಟ್ ಪರ್ಸನ್. ಇಲ್ಲ ನಾನು ಹೇಳಿರೋದು ಕೊನೆ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ದೇರ್ ಕುಡ್ ಬಿ ಹ್ಯೂಮನ್ ಎರರ್ಸ್, ದೇರ್ ಕುಡ್ ಬಿ ಜಡ್ಜಸ್ ಆರ್ ಆಲ್ಸೋ ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್ಸ್. ವಾಟ್ ಎವರ್ ಫಾರ್ reasons, these are the statutory rights. So from junior division you go to the district court, you file a RA. So you are filing this RA, December ಅಲ್ಲಿ ನಿಮ್ದು ಡಿಗ್ರಿ ಆಗಿತ್ತು plaintiff, your appeal file ಮಾಡಕ್ಕೆ ಒಂದು 90 days ಏನೋ ಟೈಮ್ ಇರುತ್ತೆ. They have filed it on the last day. ಸ್ವಲ್ಪ ಟೈಮ್ ಹೋಗಿತ್ತು, ಅವ್ರಿಗೆ ಆಗಿಲ್ಲ, ದುಡ್ಡು ಹಂಚ್ಕೊಳಕ್ಕಾಗಿಲ್ಲ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಳಕ್ಕಾಗಿಲ್ಲ, ಪ್ರಾಕ್ಟಿಕಲ್ ಪ್ರಾಬ್ಲಮ್. 2025 ಮಾರ್ಚ್ ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ. ಅದರಲ್ಲಿ ಮತ್ತೇನೋ ಒಂದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಬಂದಿತ್ತು, one date ಹೋಯ್ತು. So it is already vacation, civil vacation. Then the case came before the court by a June 2025. Notice was ordered. That notice again, that repetition. Now it is vice versa. Plaintiff had sent to the defendants. Here the appellant will send it to the respondent. Same thing repeats. So here also the due process, all called as natural justice. Without hearing the other side, you can't pass any order. So that will go repeat. So this will again, same thing will repeat, and this appeal can go up to Supreme Court. Now we are still in 2025, or before the district court. And before that, you have a very big court, High Court. I am calling big court is, it's big in the state also. And otherwise, with this pendency, it will take a big time, huge time, humongous time. In on 10 ವರ್ಷ ಕೇಸು ಅಪೀಲ್ ಸ್ಟೇಜ್ ಅಲ್ಲೇ ಇರುತ್ತೆ. ನಾನು RSA RFAಗಳು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದಾಗ 12 ವರ್ಷದಿಂದ ಇದು ಇನ್ನ ಅದು ನೋಟಿಸ್ ಆಗಿ ಒಳಗಡೆ ಎಲ್ಲೋ ಒಂದು ಕೋಲ್ಡ್ ಸ್ಟೋರೇಜ್ ಅಲ್ಲಿ ಇದೆ. ಹೊರಗಡೆ ಬರೋದಿಕ್ಕೆ ಅದು ಪಾಪ ಬೆಳಿಗ್ಗೆ ಕಾಣಿಸಿಲ್ಲ. With due respect to the courts are also overburdened. There are shortage of judges. What I am trying to tell you is how the litigation works in this country, how long it takes. It should be in a swift manner. ಒಂದು 6 ತಿಂಗಳಲ್ಲಿ ಕೇಸ್ಗಳು ಇತ್ಯರ್ಥ ಆಗಿ 1 ವರ್ಷದೊಳಗೆ ಇತ್ಯರ್ಥ ಆದ್ರೆ nothing like it. But all this, what I am trying to highlight and impress you is only upon one aspect, duration, how it gets dragged. ಇದು ಇಷ್ಟು ನಾನು ಹೇಳ್ತಾ ಇರೋದು ವಿತೌಟ್ ಎನಿ ಇಂಟೆನ್ಷನಲ್ ಡ್ರಾಗಿಂಗ್. ಇನ್ನ ಕೆಲವು ಸತಿ ನಾವೇ ಪಾರ್ಟಿಗಳು ಡ್ರಾಗ್ ಮಾಡ್ತೀವಿ. ಆಸ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಕೆಲವು ಸತಿ ಮಾಡ್ಬೇಕಾಗತ್ತೆ ಇನ್ ದಿ ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ದಿ ಪಾರ್ಟೀಸ್, ಆರ್ ದಿ ಪಾರ್ಟೀಸ್ ದೇ ವಾಂಟ್ ಟು ಪುಷ್. ಸರ್ ಇವತ್ತು ನಂಗೆ ಹುಷಾರಿಲ್ಲ ಸರ್, ಒಂದು ಟೈಮ್ ತಗೊಂಡ್ಬಿಡಿ ಸರ್, ನಾನು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲಿ ನಂಗೆ ಇವತ್ತು ರಜಾ ಸಿಕ್ಕಿಲ್ಲ ಸರ್, ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಬಂದು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಬೋಣ ಸರ್. Next date will go for 6 months. So all this will contribute for the delay. Next, I told you, suppose appeal is not filed, what happens next in civil case is execution. ನಿಮಗೆ ಏನು ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, the decree which is in your favor, that has to be executed. Who will execute it? You as a plaintiff should get it executed. You will have to file one more case for that. You get a different number. You're bored with the OS number. Now you get one different number, execution number of so and so year. Here again, practical this. Idella hogatte, matte even assuming that court is in your favor, that execution also takes place. There are all of things. Police presence ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾರೆ. ನೀವು ಆ ಕೋರ್ಟ್ ಡಿಗ್ರಿ ಇಟ್ಕೊಂಡು ಪೊಲೀಸ್ನವ್ರ ಹತ್ರ ಪ್ರತಿ ದಿವಸ ಹೋಗಿ ತೋರಿಸಿ, ಸರ್ ಕೋರ್ಟ್ ಕೊಟ್ಟಿದೆ ಮಾಡಿ 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 ಅಂತ ಹೇಳಿದ್ರು, ಸರ್ ಇವತ್ತು ನಮ್ಗಾಗಲ್ಲ, ಇವತ್ತಿಲ್ಲ, ಸಾಹೇಬ್ರು ಇಲ್ಲ, ಇನ್ಸ್ಪೆಕ್ಟರ್ ಇಲ್ಲ, ಇವತ್ತು ಇನ್ನೆಲ್ಲಿಗೋ ಹೋಗಿದ್ದಾರೆ, ಅಲ್ಲಿ ಯಾರೋ ಸೆಕ್ಯೂರಿಟಿ ಕೊಡ್ಬೇಕು. This way the police also keeps on postponing. One fine day they will also express, I'm unfortunate, I don't want to make mention before the students, but it's in reality, you will also understand. ಅಲ್ಲಿ ಏನು ಕೊಡದೆ ನೀವು ಅಲ್ಲಿ ಏನು ನಡೆಯೋದಿಲ್ಲ, ಕೊಡ್ಲೇಬೇಕು. ಆ ದುಡ್ಡು ನೀವು ಕೊಡೋದಕ್ಕೆ ಮತ್ತೆ ಅಲ್ಲಿ ನಿಮ್ ಪಾಕೆಟ್ ಇದ್ದಾನೆ ಖರ್ಚು. You will have to get it executed. If at all that gets executed, you are lucky. ಅಲ್ಲೂ ಮತ್ತೆ ಅವರು ಮತ್ತೇನೋ ಆಯ್ತು ಅಂತಂದ್ರೆ ಮತ್ತೆ ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾ ಹೋಗ್ಬೇಕು. So these are certain things. What I have tried to highlight is what are the ways and means in which the time gets wasted. I don't know if it is the appropriate word to use wasted, but this is how the time would run. But you don't get relief. Finally, every litigant wants a relief. That relief, to get that relief, it takes ages. And secondly, during the pendency of that case, if the plaintiff or the party, whoever dies, they don't enjoy. In a partition suit, if the plaintiff Ramappa dies at the age of 80 after litigating for 20 years, what is that fruit of his father's property that he has enjoyed? Nothing. All of you are mostly of this generation. ನಿಮಗೆ KGF ಬಗ್ಗೆ ಹೇಳಿದ್ರೆ ಇಷ್ಟಪಡ್ತೀರಾ. ಬಟ್ ಸ್ವಲ್ಪ ಹಿಂದೆ ಹಳೆ ಮೂವಿ ನೀವು ನೋಡಿದ್ರೆ ಭೂತಯ್ಯನ ಮಗ ಆಯು ಅಂತ ಒಂದು ಮೂವಿ ಬಂದಿತ್ತು. ಅದ್ರಲ್ಲಿ ಒಂದು ಸಿನಾರಿಯೋ ಬರುತ್ತೆ ಇದೇ ರೀತಿಯಲ್ಲಿ. ವಿಷ್ಣುವರ್ಧನ್ XYZ ಯಾರೋ ಇಬ್ರು ಕೋರ್ಟ್ಗೆಲ್ಲ ಹೋಗಿ ಎಲ್ಲಾ ಕೋರ್ಟ್ಗೂ ಅಲ್ದು ಅಡ್ವೊಕೇಟ್ ದುಡ್ಡು ಕೊಟ್ಟು ಕೊನೆಗೆ ಬರ್ತಾರೆ. ಏನ್ ಸಿಕ್ತು ಅಂತ ಹೇಳ್ತಾರೆ ಗೆದ್ದವನು ಸೋತವನು ಸತ್ತ. That's a fact. Even after 40 years, I don't think there is any change. We are still in the same process. Of course, there are technologically we have gone ahead. WhatsApp ಇದು ಬಂದಿದೆ, WhatsApp ಅಲ್ಲೂ ನೀವು ಸಮನ್ಸ್ ಕಳಿಸ್ಬೋದು, ಅದೆಲ್ಲ ಮಾಡ್ತಿದೀವಿ. ಬಟ್ ಆ ಫ್ಯಾಕ್ಟ್ ಏನಿದೆ ಅವ್ರು 40 years ಹಿಂದೆ ಆ ಮೂವಿಯಲ್ಲಿ ಡಿಪಿಕ್ಟ್ ಮಾಡಿರೋದು, more or less the scenario is still same. It still persists. So what is that we have to do is our next part of discussion. Before that, I think Prashanth Chandra sir, if he wants to add something, sir, please add.
Thank you, Trivikram. By the way you have explained, I am also feeling threatened to go to the court now. Fortunately, I am in Bangalore and I have no properties, so it's okay. If you ask me to go to Tumkur or Bagalkot or Bidar, I think I would say rather I would give up the property rather than fight for the rights. I wish the questions should come from the participants. Please, all of you open your cameras. Let us see. Mr. Mahesh.
And my endeavor was not to threaten or make you feel scary about courts. It's only the hard reality what I have tried to highlight.
Correct.
And some of them, like Mr. Mahesh, would agree with us with his age and experience.
I can only agree from a personal experience. We just went through a partition suit. For 11 years, somebody filed a partition suit, and this did not even go to the next stage. And for 11 years, 4 of the parties passed away. And then basically in the last Lok Adalat, it was basically dismissed. So 11 years passed, 4 people passed away, and nothing was gained out of it.
Correct. Yes, Shweta TG. Welcome.
Yeah, thank you.
Please ask your questions. Anything related to what we have so far covered. You also have a lot of experience of your own.
Basically, I have found the similar experience from 2010. I have there's a file case in the case is filed in Dodbalapur. So it's been pending from 2010. So it's going like evidence. All the plaintiff and the defendants who had filed the case initially are no more now. The LRs are taking care of it, and it is going on and going on and going on. That is a big issue that I'm finding in solving this case.
Good. You have shared your experience.
Yeah.
Chetan.
Sir, if this is
Ambu, please go ahead, proceed.
Sir, in last 1 month we are studying ADR, sir. They are the proceeding itself very easy and very flexible manner. Why won't we change our in court proceeding into the ADR like that, sir?
That's the purpose of this whole 2-day program. We know that there are alternatives. How does it work? It is easier said than done. See, you can be theoretically learning what is ADR, how it works, but finally it has to be practically implemented. If I'm asked to go to Bombay from here in my car, I would go to Google and see, and it may say 1,200 kilometers, and I may go. But there may be some suggestion given by Shweta saying that, sir, if you are very keen to go very fast, after Tibel, you take left, and then, after that you get the diversion, then you take right. From there you go there, you get 20 kilometers, you get left. Then again you go further, you get a coffee day, then you take right, then you get a toll. Finally, you reach Bombay, less than 1,000 kilometers. But I don't know where to take right, where to take left, where is that coffee day? In search of coffee day, I would be spending more time and I would reach probably more than 1,200 kilometers time. So you should know how to use this ADR in which place. That's exactly the purpose of this. We all know that there is ADR. The textbooks say these are the subjects which are given to you. These are ADRs, very simple. Which ADR is what? Each one serves different purposes. It is not that, A is same as B, B is same as C, C is same as D. I still remember some of my colleagues in the bar who have been put more than even 30 years. If you ask them, they say, I don't see there is any difference between arbitration, conciliation, mediation. It's all the same. It is not. That's why I said the nuances should be known. Where we should use, we should know. Which ADR is appropriate, we should know. Then only it becomes more practical. That's exactly why I introduced this. First, we should know the hierarchy of the courts. We should know how the system works. Then we know how the alternatives work. Then it becomes easier to know where I can opt for which alternative. And then probably it makes easier for us. If it has worked for Shweta in A case, it doesn't mean that it works for me in another B case. It could change because the parties are different in each case. The mindset of the parties are different in each case. In a particular case where Mr. Mahesh put it, maybe VP Mahesh put it, it could be 70-year-old people who are in the legal battle. In another case, it could be a man of 40 who will be able to take some big risk. Or it could be a man who is very rich and he may be able to take some alternatives and take a costlier route. So it depends on persons, it depends on facts of each case. So I would always say, before actually we are not even introduced ADR, ADR is alternative dispute redressal mechanism. Actually, it is appropriate dispute redressal mechanism. What is appropriate to each litigant? That has to be seen. That's the purpose of ADR. Yes, Ambu, anything else good that you shared? See, this has to be
No,
interactive
sir.
session. There is no
Thank
point
you,
in
sir.
teaching. It has to be an interactive session. Unless you come out with some thoughts which you have, we will also not know how to answer you, what to answer. So my request to all of you, Chetan, Sarvana Kumar, Ankit, please open your windows, participate. Ask questions. Yes, Gokul. Here we are covering theory very simply, shortly. We have kept interaction time. That's the reason why we are giving more time to you. Any amount of theory without interaction may not help you. Yes, Gokul, go ahead, please.
Sir, I have no doubts, sir.
You have no doubts.
Yeah, yeah.
You have a doubt? I didn't understand you.
No, sir, I have no doubts.
Okay.
Sir,
Anybody else?
Chetan, I have a doubt.
Chetan, yes.
Sir, you said
Camera open, Madi.
summons. Okay, 1 minute. Okay.
Yes.
ಸಮನ್ಸ್ ವರ್ಕ್ ಡಿಪೆಂಡೆಂಟ್ ಗೆ ಸಮನ್ಸ್ ಸಿಕ್ಕಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ರ ಅಥವಾ ಅವಾಯ್ಡ್ ಮಾಡ್ತಿರ್ಬೋದು. ಕೋರ್ಟ್ ಲೈಕ್ ನ್ಯೂಸ್ ಪೇಪರ್ ಅಲ್ಲಿ ಹಾಕೋದು ಅಥವಾ ಅವ್ರ ಮನೆ ಮೇಲೆ ಸಮನ್ಸ್ ನ ಅಂಟಿಸೋದು, ಕೋರ್ಟ್ ಇಂದ ಆರ್ಡರ್ ತಗೊಂಡು ಈ ತರ ಮಾಡಿದ್ರೆ ಬೇಗ ಎಕ್ಸ್ಪೆಡೈಟ್ ಆಗಲ್ವಾ?
Trivikram, will you please answer that?
ಸಮನ್ಸ್ ಅವ್ರಿಗೆ ರೀಚ್ ಆಗೋ ತರ ಮಾಡಿ ಅವ್ರನ್ನ ಕೋರ್ಟ್
ಹೇಳಿದ್ನಲ್ಲ ನಿಮ್ಗೆ, ಇದೆಲ್ಲ ಮಾಡೋ ಅಷ್ಟೊತ್ತಿಗೆ ನಮ್ಗೊಂದ್ 2-2.5 ವರ್ಷ ಮುಗಿಯುತ್ತೆ. ಆಯ್ತಾ? ನೀವದು ಕೆಲವು ಸತಿ 3 ಸತಿ 4 ಸತಿ ಸಮನ್ಸ್ ಹೋಗಿ ವಾಪಸ್ ಬರೋವರೆಗೂ ಅವ್ರ ಪೇಪರ್ ಅಲ್ಲಿ ಪಬ್ಲಿಷ್ ಮಾಡೋದಕ್ಕೆ ಕೋರ್ಟ್ ಅಲೋ ಮಾಡೋದಿಲ್ಲ ನಿಮ್ಗೆ. ಸಬ್ ಸರ್ವಿಸಸ್ ತಗೊಂಡು ನಿಮ್ಗೆ ಅವ್ರ ಮನೆ ಮುಂದೆ ಕಾನ್ಸ್ಪಿಕ್ಯೂಸ್ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಅಂಟಿಸ್ಬಿಟ್ಟು ಬರೋದಿಕ್ಕೆ ಇದಕ್ಕೆಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ನೀವು ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ ದಿವಸದಿಂದ 1-2 ವರ್ಷ ತಗೊಳತ್ತೆ. ಯಾಕಂದ್ರೆ 1-2 ತಿಂಗಳು ಬಿಟ್ಟು ಡೇಟ್ ಕೊಡ್ತಾ ಇರ್ತಾರೆ. ಸೊ ಆ 2 ವರ್ಷನೂ ನೀವು ಕಳ್ಕೊತಾ ಇದ್ದೀರಾ. ಅಂಡ್ ಈ 2 ವರ್ಷದಲ್ಲಿ ಕೋರ್ಟ್ ನೀವು ಅಡ್ವೊಕೇಟ್ಗೆ ಪ್ರತಿ ಅಪಿಯರೆನ್ಸ್ಗೂ ಫೀಸ್ ಕೊಡ್ಬೇಕು. ನಾನೇನ್ ಹೇಳ್ತಾ ಇರೋದೆಲ್ಲ ನೋಡಿದ್ರೆ ನಮ್ಮ ಹತ್ರ ಯಾರು ಬರೋದೇ ಇಲ್ಲ, ನೆಕ್ಸ್ಟ್ ನಮ್ಗೆ ಫೀಸ್ ಬರೋದಿಲ್ಲ, ಡಿಫ್ರೆಂಟ್ ಥಿಂಗ್. ಬಟ್ ನಾನು ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತಂದ್ರೆ ಪ್ರತಿ ಸತಿ ಖರ್ಚಲ್ವಾ, ನಾವು ಅದನ್ನು ನೋಡ್ಬೇಕಲ್ವಾ, ಖರ್ಚನ್ನು ನೋಡ್ಬೇಕು ಪ್ರತಿಯೊಬ್ಬರಿಗೂ. ಅದು ಫೀಸ್ ಒಬ್ರಿಂದ ಒಬ್ರಿಗೆ ವೇರಿನೂ ಆಗ್ತಾ ಇರುತ್ತೆ. ಒಬ್ರಿಗೆ 500 ರೂಪಾಯಿ ಇರ್ಬೋದು, ಒಬ್ರಿಗೆ 5,000 ಇರ್ಬೋದು, ಒಬ್ರಿಗೆ 5 ಲಕ್ಷ ಇರ್ಬೋದು, ಒಬ್ರಿಗೆ 50,000 ಇರ್ಬೋದು, ಡಿಪೆಂಡಿಂಗ್ ಅಪಾನ್ ದಿ ಅಡ್ವೊಕೇಟ್. ಆ ದುಡ್ಡನ್ನು ನೀವು ಕಳ್ಕೊತಾ ಇದ್ದೀರಾ, ಆ 2 ವರ್ಷನೂ ನೀವು ಕಳ್ಕೊತಾ ಇದ್ದೀರಾ. ಜೊತೆಗೆ ನಾವೇನ್ ಹೇಳ್ತಾ ಇರೋದು, ಆ ವಯಸ್ಸಾಗಿರುವಂತವ್ರು ನೀವು ಕೇಸ್ ಫೈಲ್ ಮಾಡಿ ಅದರ ಪ್ರತಿಫಲ ಅಥವಾ ಅದರ ಒಂದು ಫ್ರೂಟ್ಸ್ ನ ಅನುಭವಿಸೋದಕ್ಕಿಂತ ಮುಂಚೆನೆ ಅವ್ರು ತೀರೋದು ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಏನ್ ಸಿಕ್ತು? ಕೇಸ್ ಹಾಕದೆ ಅನ್ನೋ ಖುಷಿ ಸಿಗತ್ತ ಅದ್ರಲ್ಲಿ, ಕೇಸ್ ಫೈಲ್ ಮಾಡದೆ ಅಂತ? ಇಲ್ಲ ಅಲ್ವಾ? ಸೊ ಅದರಿಂದ ಬೆನಿಫಿಟ್ ಸಿಗ್ಬೇಕು. ನಮಗೆ ಏನ್ ಆ ಬೆನಿಫಿಟ್ ಸಿಗತ್ತೆ, ಆ ಬೆನಿಫಿಟ್ಗೋಸ್ಕರ ನಾವು ಕೇಸ್ ಫೈಲ್ ಮಾಡಿರ್ತೀವಿ. ಅದರದ್ದು ಟೈಮ್ ಅಷ್ಟಾಗತ್ತೆ ಅಂತ ಹೇಳಿದೆ. ಅದಕ್ಕೆ CPC ಅಲ್ಲಿ ಇನ್ನ ದೀರ್ಘವಾಗಿ ಹೇಳಿರ್ತಾರೆ, ನಿಮ್ಗೆ ಬೇಕಾದಷ್ಟು ಆಪ್ಷನ್ಸ್ ಇರುತ್ತೆ. ಬಟ್ ಇದೆಲ್ಲಾನು ಟೈಮ್ ಕನ್ಸ್ಯೂಮಿಂಗ್. ಇಟ್ ವಿಲ್ ಟೇಕ್ ಅಟ್ ಲೀಸ್ಟ್ ಒನ್ ಮಂತ್ to 15 days ಅಲ್ಲಿ ಆಗುವಂತದ್ದಲ್ಲ ಇದು. ಇಟ್ಸ್ ಆಲ್ ಟೈಮ್ ಕನ್ಸ್ಯೂಮಿಂಗ್. ಮಿನಿಮಮ್ 6 months, 1 year, 2 years. ಕೆಲವು ಕೇಸ್ಗಳು ನೀವು ಹೋಗಿ ನೋಡಿದ್ರೆ 4 ವರ್ಷ 5 ವರ್ಷ ಆ ಸಂಬಂಧ ಸ್ಟೇಜ್ ಅಲ್ಲೇ ಇರುತ್ತೆ. ಅದು ಪಾರ್ಟಿಗೂ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ, ಇವಾಗ ಅಡ್ವೊಕೇಟ್ಗೂ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ. ಜಡ್ಜ್ ಅವ್ರು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕು, ಅವರು ಒಂದಷ್ಟು ದಿವಸ ನೂಕಿ ಅದೊಂಥರ ಆಕ್ಸಿಜನ್ ಇಲ್ಲದೆ ನೀವು ಇದನ್ನ ಮಾಸ್ ತೆಗ್ದಿದ್ದೀರಾ. ಅದು ಯಾವಾಗ ಸಾಯತ್ತೆ ಗೊತ್ತಿಲ್ಲ. ಅವರೇ ಒಂದ್ ದಿವಸ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅಂತ ವಜಾ ಮಾಡ್ತಾರೆ. ಅಲ್ಲಿವರೆಗೂ ಹೋಗಿರುತ್ತೆ. ಯಾಕೆಂದ್ರೆ ಅದ್ ಏನು ಮುಂದೆ ಹೋಗ್ತಾ ಇಲ್ಲ. ನೀವು ಹೇಳ್ದಂಗೆ ಅದ್ ಮಾಡ್ಬೋದು, ಇದೆ ಆಪ್ಷನ್ಸ್ ಇದೆ. ಅದು ಎಫೆಕ್ಟಿವ್ ಆಗಿದ್ಯಾ ಅಥವಾ ಡಂಗೂರ ಹೊಡಿಸಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಇವಾಗ ಅದೆಲ್ಲ ಹಿಂದಿನ ಕಾಲಕ್ಕೆ ಅಪ್ಲೈ ಆಗ್ತಿದೆ. CPC ಅಲ್ಲಿ ನಿಮ್ಗೆ ಹೇಳುತ್ತೆ ಪ್ರೊಕ್ಲಮೇಶನ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಆ ಟಾಮ್ ಅದೆಲ್ಲ ನಿಮ್ಗೆ ಇವಾಗ ಯಾರು ನೀವು ನಿಮ್ ರೋಡಲ್ಲಿ ಪಕ್ಕ ನಿಮ್ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ ಯಾರಿದಾರೆ, ನೆಕ್ಸ್ಟ್ ಪಕ್ಕದ ಮನೆ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಯಾರಿದಾರೆ ಅವ್ರ ಹೆಸರು ಗೊತ್ತಿಲ್ಲ. 4 ಜನ ಇದಾರ, 3 ಜನ ಇದಾರ, ಅವರು ಕೆಲ್ಸಕ್ಕೆ ಹೋಗ್ತಾ ಇದಾರ, ಸ್ಟೂಡೆಂಟ್ಸ್ ಗೊತ್ತಿಲ್ಲ. ಇವಾಗಿರೋ ನಾವು ಬೆಂಗಳೂರಲ್ಲಿ ಅಂತದ್ರಲ್ಲಿ ನೀವು ಅವೆಲ್ಲ ಟಾಮ್ ಮಾಡಿ ಅಲ್ಲಿ ಅದೆಲ್ಲ ವರ್ಕೌಟ್ ಆಗ್ಬೇಕು. ಇವತ್ತಿನ ಪ್ರಸ್ತುತ ಸಿನಾರಿಯೋಗೆ ಏನಿದೆ ಅದಕ್ಕೆ ನೀವು ಹೋಗ್ಬೇಕಾಗತ್ತೆ. ಟೆಕ್ನಾಲಜಿನೆಲ್ಲ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡುವಂತದ್ದು CPC ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗ್ಬೇಕು. ಅದಕ್ಕೆಲ್ಲ ಅದು ಇಂಪ್ಲಿಮೆಂಟ್ ಆಗಿ ಅದು ಹೇಗೆ ಸಕ್ಸಸ್ಫುಲ್ ಆಗತ್ತೆ ಅಂತ ನೋಡೋ ಅಷ್ಟೊತ್ತಿಗೆ ಇನ್ನ 10 ವರ್ಷ ಹೋಗುತ್ತೆ ನಮ್ಮಲ್ಲಿ. ಅರ್ಥ ಆಯ್ತಾ? ನಾನು ಆ ಪ್ರಾವಿಷನ್ಸ್ ಇಲ್ಲ ಅಂತ ನಾನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಬಟ್ ಆ ಪ್ರಾವಿಷನ್ಸ್ ಇರೋದು ಟೈಮ್ ಕನ್ಸ್ಯೂಮಿಂಗ್. ಸಿ, ಆಲ್ ಆಫ್ ಅಸ್ ವಾಂಟ್ ಕ್ವಿಕ್ ರಿಲೀಫ್. ನೀವು ಬೇಲ್ ಬೇಕು, ನಿಮ್ಮನ್ನ ಅರೆಸ್ಟ್ ಮಾಡೋದಕ್ಕೆ ಪೊಲೀಸ್ನವ್ರು ಹಿಂದೆ ಬಿದ್ದಿದ್ದಾರೆ. ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ಗೆ ನಾವು ಆತರ ಎಲ್ಲ ಮಾಡ್ಕೊಂಡು 4 ವರ್ಷ ಹೋದ್ರೆ ನೀವು ಒಪ್ಕೋತೀರಾ? 4 ವರ್ಷ ಅಲ್ಲ, 4 ದಿವಸ ಲೇಟ್ ಆದ್ರೆ 1000 ಸತಿ ಫೋನ್ ಮಾಡ್ತೀರಾ, ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಮಾಡ್ತೀರಾ. ಸರಿ ಇಲ್ಲ, ಅಡ್ವೊಕೇಟ್ ಓವರ್ ನೀವು ಫೋನ್ ಮಾಡೋದು ಅರ್ಧ ಗಂಟೆಲಿ ಬೇಕು. ಇವಾಗಂತೂ ಫೋನ್ ಮಾಡಿದವ್ರಿಗೆ ಸ್ವಿಗ್ಗಿನ ಝೊಮ್ಯಾಟೋನ ಅದಕ್ಕಿಂತ ಫಾಸ್ಟ್ ಆಗಿ ಅಡ್ವೊಕೇಟ್ಸ್ ರಿಲೀಫ್ ಕೊಡ್ಬೇಕು. ದಿಸ್ ಇಸ್ ವಾಟ್ ದೇ ಎಕ್ಸ್ಪೆಕ್ಟ್. ನಿಮಗೂ ನೀವು ಡಾಕ್ಟರ್ ಹತ್ರ ಹೋಗ್ತೀರಾ, ಫಾರ್ ಎ ಮೂಮೆಂಟ್ ನೀವು ಲಾಯರ್ ಆಗ್ತೀರಾ. ಮುಂದೆ ಒಂದು ಎಕ್ಸಾಂಪಲ್ ಕೊಡ್ತೀನಿ. ಡಾಕ್ಟರ್ ಹತ್ರ ಹೋಗ್ತೀರಾ, ನೀವು ತಲೆನೋವು ಅಂತ, ಆ ತಲೆನೋವು ಅವ್ರು ಹೋಗ್ತೀರಾ, ಅರ್ಧ ಗಂಟೆ ಅವ್ರ ಕ್ಲಿನಿಕ್ ಅಲ್ಲಿ ವೆಯ್ಟ್ ಮಾಡ್ತೀರಾ, ಒಂದು ಪ್ರಿಸ್ಕ್ರಿಪ್ಷನ್ ಬರ್ಕೊಡ್ತಾರ, ಅವ್ರ ಕೈಯಲ್ಲಿ ಒಂದು 500 ರೂಪಾಯಿ ಇಡ್ತೀರಾ, ಅದು ಮೆಡಿಕಲ್ ಶಾಪ್ ಹೋಗ್ತೀರಾ, ಒಂದು 200 ರೂಪಾಯಿ ಖರ್ಚು ಮಾಡ್ತೀರಾ, ಟ್ಯಾಬ್ಲೆಟ್ ತಿಂತಾ ಇದ್ದೀರಾ. ತಿನ್ನೋದು ಮತ್ತೆ ಇದನ್ನೇ ರಿಪೀಟ್ ಮಾಡಿ ಒಂದು 4 ವಾರ, ನಿಮ್ ತಲೆನೋವು ಮಾತ್ರ ಹೋಗ್ತಾ ಇಲ್ಲ. ಏನ್ ಮಾಡ್ತೀರಾ ನೀವು ಅಂತ ಟೈಮಲ್ಲಿ? ಟ್ಯಾಬ್ಲೆಟ್ಸ್ ಚೇಂಜ್ ಮಾಡ್ತಾ ಇದಾರೆ, ಟ್ಯಾಬ್ಲೆಟ್ಸ್ ಚೇಂಜ್ ಮಾಡ್ತಿದ್ದಾರೆ, ಅದೇ ಟ್ಯಾಬ್ಲೆಟ್ ಪ್ರಿಸ್ಕ್ರೈಬ್ ಮಾಡ್ತಿಲ್ಲ. ನೀವ್ ಹೇಳಿದ್ರಲ್ಲ ಅದಿದೆ, ಅದು ಕಾನ್ಸ್ಪಿಕಸ್ ಇದರಲ್ಲಿ ಅಂಟಿಸ್ಬೋದು ಅದೆಲ್ಲ ಅಂತ. ಅದೇ ತರ ಇಲ್ಲಿ ಬೇರೆ ಆಲ್ಟರ್ನೇಟಿವ್ಸ್ ಇದೆ. ಫಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ನಿಮ್ಗೆ ಕಾಂಬಿಫ್ಲಾಮ್ ಕೊಟ್ಟಿದ್ರು, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಡಾಟ್ ಕೊಟ್ರು, ಇನ್ನೊಂದ್ಸತಿ ಮತ್ತೊಂದು ಕೊಟ್ರು. ಟ್ಯಾಬ್ಲೆಟ್ಸ್ ಚೇಂಜ್. ಇಲ್ಲೂ ಅಷ್ಟೇನೆ, ಪ್ರೊಸೀಜರ್ಗಳು ಬೇರೆ ಬೇರೆ ನೀವು ಸಮನ್ಸರ್ ಮಾಡ್ತಿದ್ದೀರಾ. ಬಟ್ ನಿಮ್ ತಲೆನೋವು ಹೋಗಿಲ್ಲ. ಅದನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಂಡು ನೀವೇ ಹೇಳಿ, ನಿಮ್ಮಲ್ಲೇ ಉತ್ತರ ಇದೆ.
ಬಟ್ ಇದಕ್ಕೆ ಶಾರ್ಟ್ ಕಟ್ ಏನಂತ ನೀವೇ ಹೇಳ್ಬೇಕು ಸರ್. ನಮ್ಮ ನಾಲೆಡ್ಜ್
ನೆಕ್ಸ್ಟ್ ಅಲ್ಲ, ಅದನ್ನೇ ಅಲ್ಲಿಗೆ ಬರ್ತೀವಿ.
ಚೇತನ್, ನಿಮ್ಮ ಪ್ರಶ್ನೆಯ ಬಹುಶಃ ಸಾರಾಂಶ ಏನಂದ್ರೆ, ನಾವು ಯಾಕೆ ಫಸ್ಟ್ ಗೇರ್ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು, ಸ್ಟ್ರೇಟ್ ಆಗಿ 4th ಗೇರ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಡ್ಬೋದಲ್ವಾ ಅಂತ ನೀವು ಕೇಳ್ತಿರೋದು.
ಹೌದು ಸರ್, ಸ್ಟೆಪ್ ಬೈ ಸ್ಟೆಪ್ ಅಂತಂದ್ರೆ ನೀವು ಹೇಳ್ದಂಗೆ ವರ್ಷ.
ಹೌದು, ಫಸ್ಟ್ ಹಾಕಿ, ಸೆಕೆಂಡ್ ಹಾಕಿ, ಗುಂಡಿ ನಿಲ್ಸ್ಬಿಟ್ಟು ಸ್ಲೋ ಮಾಡಿ, ಮತ್ತೆ ಜರ್ಕು, ಕ್ಲಚ್ಚು, ಆಕ್ಸಿಲೇಟರ್ ಅದೆಲ್ಲ ಬೇಡ, ಸ್ಟ್ರೇಟ್ 4th ಗೇರ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಡಿ ಸರ್, ಬೇಗ ಮುಟ್ಬಿಡ್ಬೋದು ಅಂತ. ಕರೆಕ್ಟ್. ಒಂದ್ ಏನಂದ್ರೆ ನೋಡಿ, ಯೋಚನೆ ಮಾಡಿ, why do we assume that everybody is awaiting the notice? Some people are not awaiting. Firstly, the notice is usually believed to be taken. Postman is the most dependent service in India now. ಸಾಧಾರಣವಾಗಿ ರಿಜಿಸ್ಟರ್ಡ್ ಪೋಸ್ಟ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಹೋಯ್ತು ಅಂದ್ರೆ ಯಾರು ತಗೊಳ್ದಿರಲ್ಲ, ಪೋಸ್ಟ್ ಮ್ಯಾನ್ ಅವರು ಮೋಸ ಮಾಡಲ್ಲ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಗಳಿದೆ. ನಾವು ಮಾತಾಡ್ತಾ ಇರೋದು ಆಲ್ 100 ಕೇಸಸ್ ಅಲ್ಲ, ಮೇ ಬಿ 5% of them evade. 95% of them receive it. The cost of a registered post notice is probably 30 rupees. The cost of a paper publication is probably 40,000. So for 5% people, do you want to make the rest 95% of the people spend 40,000 per notice? ಒಂದು.
This is
ಎರಡನೇದು,
because we don't
ಆತ
know the-
ಅಲ್ಲಿ ಇದ್ದು ಅವಾಯ್ಡ್ ಮಾಡ್ತಾ ಇದ್ದಾನ, ಆತ ಅಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ವಾ? ಈಗ ನಾನು ವಿಜಯನಗರದಲ್ಲಿ ನನ್ನ ಅಡ್ರೆಸ್ ಅಂತ ಕೊಟ್ಟಿರ್ತೀನಿ, ನೀವು ಕೇಸ್ ಹಾಕೋ ಸಮಯದಲ್ಲಿ ಬಹುಶಃ ನಾನು ಐ ವುಡ್ ಹ್ಯಾವ್ ಶಿಫ್ಟೆಡ್ ಟು ರಾಜಾಜಿನಗರ್. If my notice comes to Vijayanagar address, it may say he has left. I'm not awaiting. If it come to me, I have received it. Then if I am not coming to the court, then only I am avoiding. Then you can say, sir, he is deliberately doing it. Please take paper publication. So one sati notice ಹೋಗಿ ಬರುತ್ತೆ, ರಿಸೀವ್ ಆಗಿಲ್ಲ. ಎರಡನೇ ಸತಿ ಮತ್ತೆ ಕಳಿಸ್ಬೇಕಾಗತ್ತೆ, ಆಗ್ಲೂ ಅಲ್ಲಿ ರಿಸೀವ್ ಆಗಿಲ್ಲ. ಆಗ ಡೌಟ್ ಬರುತ್ತೆ, ಮೂರನೇ ಸತಿಗೆ ಆಗುವಾಗ ಬಹುಶಃ ಅವ್ನು ಡೆಲಿಬ್ರೇಟ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾನೆ. ಮಧ್ಯದಲ್ಲಿ ಲೆಫ್ಟ್ ಅಂತ ಬಂದ್ರೆ, ಇಟ್ ಇಸ್ ಎ ಜಾಬ್ ಆಫ್ ದಿ ಪ್ಲೇಂಟಿಫ್ ಟು ಲುಕ್ ಫಾರ್ ದಿ ಆಲ್ಟರ್ನೇಟ್ ಅಡ್ರೆಸ್ ಆಫ್ ದಿ ಪಾರ್ಟಿ. ಐ ಆಮ್ ಇನ್ ನಾವು ರಾಜಾಜಿನಗರ್ ಅಂತ ಹುಡ್ಕೋ ಕೆಲಸ ಅವನಿಗೆ ಹುಡ್ಕಕ್ಕೆ ಒಂದು 3 ತಿಂಗಳು ಬೇಕಾಗತ್ತೆ. ಇಲ್ಲಿ ಜಡ್ಜ್ ಡಿಲೇ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಲಾಯರ್ ಡಿಲೇ ಮಾಡ್ತಾ ಇರಲ್ಲ, ಪಾರ್ಟಿಗಳಿಂದನೂ ಸಹಕಾರ ಬೇಕಾಗ್ತದೆ. ಅವನು ತಂದು ಕೊಡ್ಬೇಕಾಗತ್ತೆ. ತಂದು ಕೊಟ್ಟಾಗ ಅವನು ವಿಜಯನಗರದಲ್ಲಿ ಬದಲು ರಾಜಾನಗರದಲ್ಲಿ ತಗೊಂಡು ಮುಗಿದೋಯ್ತು. ಇಲ್ಲ ಡೆಲಿಬ್ರೇಟ್ಲಿ ಅಲ್ಲೂ ಮಾಡ್ತಾ ಇದ್ದಾನೆ ಅಂದಾಗ ಮೂರನೇ ಸತಿಗೆ ಬೇಕಿದ್ರೆ ನೀವು ಯು ಕ್ಯಾನ್ ಸೇ Prashanth Chandra is deliberately avoiding the notice. Therefore, the only way is to see that it is published in the paper. Please note, the plaintiff has to bear the expenses. All plaintiffs will not be ready. They want justice. Doesn't mean that they want to spend money on paper publication itself for 40,000. ಆಗಷ್ಟೇ ಕೋರ್ಟ್ ಫೀ ಒಂದು 50,000 ಕಟ್ ಮಾಡಿಸಿ ಬಂದಿರ್ತಾನವನು. ಇನ್ನೊಂದು 40,000 ಅಂದ್ರೆ ಅಲ್ಲಿ 1 ಲಕ್ಷ ಆಗೋಯ್ತಲ್ಲ ಅವನಿಗೆ ಖರ್ಚು. ಅವನಿಗೆ ಇನ್ನು ಇದಕ್ಕೆ that's exactly what I'm saying. You are the youngsters. You have to find solutions to this. ಬಹುಶಃ ಈಗ ಆಧಾರ್ ಕಾರ್ಡ್ ಅಂತ ಬರ್ತಾ ಇದೆ, ಪ್ಯಾನ್ ಕಾರ್ಡ್ ಅಂತ ಬರ್ತಾ ಇದೆ. ಇದರಿಂದೆಲ್ಲ ಬಹುಶಃ ಇನ್ನೂ ಹೊಸ ರಿಫಾರ್ಮ್ಸ್ ಆಗ್ಬೇಕಾಗತ್ತೆ. ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಎಲೆಕ್ಟ್ರಾನಿಕ್
ಇಮೇಲ್ ಅಲ್ಲಿ ಕಳಿಸೋದು,
ಇಮೇಲ್ ಅಲ್ಲಿ ಕಳಿಸ್ಬೇಕಾಗತ್ತೆ. ಇದೆಲ್ಲ ಹೊಸದು. ಇಡೀ ನಮ್ಮ ದೇಶದಲ್ಲಿ ಎಷ್ಟು ಜನ ಹತ್ರ ಇಮೇಲ್ ಇದೆ? ಎಲ್ಲೋ ಒಂದು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಒಂದು 25-30% ಯಂಗ್ಸ್ಟರ್ಸ್ ಲೈಕ್ ಯು ಅಂಡ್ ಅಸ್, we have emails and etc. You go to Tumkur, I don't think there is many people having emails. So you cannot say email check compulsory.
ಚೇತನ್, ನಿಮ್ಮ ಇನ್ಬಾಕ್ಸ್ ನ ನೀವು ಎಷ್ಟು ದಿವಸಕ್ಕೊಮ್ಮೆ ಚೆಕ್ ಮಾಡ್ತೀರಾ? ಫೇಸ್ಬುಕ್ ಅಲ್ಲ, ಜಿಮೇಲ್ ಇನ್ಬಾಕ್ಸ್. ರೇರ್ಲಿ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಒಂದು ಕೋರ್ಟ್ ಸಮನ್ಸ್ ಬಂದಿರೋದು ಹೋಗಿ ಸೇರ್ಕೊಂಡಿದೆ. ಅದು ಕೆಲವು ಸತಿ ಟ್ರಾಶ್ ಇದು ಇರುತ್ತಲ್ಲ, ಯಾವುದು ಸ್ಪ್ಯಾಮ್ ಬಾಕ್ಸ್ಗೂ ಹೋಗಿರ್ಬೋದು. ಈಗ KLE ಕಾಲೇಜ್ನವ್ರು ಒಂದು ಇನ್ವೈಟ್ ಕಳ್ಸಿದ್ರು, ಅದು ಸ್ಪ್ಯಾಮ್ ಬಾಕ್ಸ್ ಹೋಗಿತ್ತು. ನಾನು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೆ. ಸಾರಿ ಸರ್, ಇಂಟರಪ್ಟ್ ಮಾಡಿದೆ.
ಇಲ್ಲ ಪ್ಲೀಸ್. ಫೈನಲಿ ದ ಐಡಿಯಾ ಇಸ್, ಚೇತನ್, ದಿಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಎ ಪ್ರಾಕ್ಟಿಕಲ್ ಸೆಷನ್, ನಾಟ್ ಜಸ್ಟ್ ಥಿಯರಿ. ಬಂದು ಹೇಳ್ಬಿಟ್ಟು ಹೊರಟೋದ್ರು ADR ಕೋರ್ಸ್ ಆಯ್ತು ಅಲ್ಲ. ಇದೆಲ್ಲ ಚಿಂತನೆಗಳು ನಿಮ್ಮಲ್ಲಿ ಆಗ್ಬೇಕು. ನೀವು ಇದಕ್ಕೆ ಒಂದು ಉತ್ತರ ಕಂಡುಹಿಡಿಬೇಕು. You are now the new generation. Yes sir, please proceed. Ask.
ಸಾಫ್ಟ್ ಕಾಪಿನ ಲೈಕ್ ನಾವು ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಕಳಿಸಿದ್ರೆ ವ್ಯಾಲಿಡ್ ಇದೆಯಾ ಅದು?
Trivikram,
ನಾನು ನಿಮ್ಗೆ ಹೇಳ್ದೆ ಅಲ್ಲ, ಇದೆಲ್ಲಾನು ಇವಾಗ ಇನ್ಫ್ಯಾನ್ಸಿ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ. ಈಗ ನಾವು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೆಲವು ಸತಿ ಜಡ್ಜಸ್ ಹೇಳ್ತಾ ಇದಾರೆ, ಈ ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ನಾವು ಕಾಪಿ ಸರ್ವ್ ಮಾಡೋದು, IA ಸರ್ವ್ ಮಾಡೋದು, ಇವೆಲ್ಲ ಮಾಡ್ತಾ ಇದೀವಿ. ಅದಕ್ಕೆ ಕಾನೂನಿನ ಬ್ಯಾಕಪ್ ಇದೆಯಾ ಇಲ್ವಾ ನಮಗ್ ಗೊತ್ತಿಲ್ಲ, ಆಯ್ತಾ? ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ನಾವು ಈ ಝೂಮ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ ಶುರು ಮಾಡಿದಾಗ ಬೇಕಾದಷ್ಟು ಜನ ಲಾಯರ್ಸ್ ಅವಾಗಿದ್ದಂತ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಅವರಿಗೆ ಹೇಳಿದ್ರು, ಇದಕ್ಕೆ ಕಾನೂನಲ್ಲಿ ಎಲ್ಲ ಅವಕಾಶ ಇದೆ, ನೀವು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ತೀನಿ ಅಂತೀರಾ, ಅದ್ ಮಾಡ್ತೀನಿ ಅಂತೀರಾ ಅಂತ. ಇವಾಗ ನಮ್ಗೆ ಅದಕ್ಕೆ ರೂಲ್ಸ್ ಇದೆ, ಅದು ಕಾನೂನು ಬದ್ಧವಾಗಿ ನಡೀತಾ ಇರುವಂತದ್ದು. ನಮಗೆ ಅಮೆಂಡ್ ಮಾಡಿದ್ದಾರೆ, ಮತ್ತೆ ಅದಕ್ಕೆ ರೂಲ್ಸ್ ಇದೆ, ಆಯ್ತಾ? ಸೊ ನಾವು VC ಅಲ್ಲಿ ನಿಮ್ಗೆ ಒಂದು ಓನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ದಟ್ಸ್ ಅ ವ್ಯಾಲಿಡ್ ಪೀಸ್ ಆಫ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಬಹುದು. ಮುಂಚೆ ಇರ್ಲಿಲ್ಲ. ಹಾಗಾಗಿ ಈಗ ಥಿಂಗ್ಸ್ ಚೇಂಜ್ ಆಗ್ತಿದೆ. ನಾನು ಅದನ್ನೇ ನಿಮ್ಗೆ ಹೇಳಿದ್ದು, CPC ಅಮೆಂಡ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿದೆ. CPC ಅಮೆಂಡ್ ಆಗುವಂತ ಸಮಯ ಬಂದಿರ್ಬೋದು. ನಿಮಗೆ ವಾಟ್ಸಪ್ ಅಲ್ಲಿ ಮತ್ತೆ ಇಮೇಲ್ ಅಲ್ಲಿ ಇದನ್ನೆಲ್ಲ ಕಳಿಸುವಂತದ್ದು ಇವಾಗ ಆಗ್ಲೇ ಕೋರ್ಟ್ ಮೇಡ್ ಲಾ ಇದೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದೆ, ಫ್ಯಾಮಿಲಿ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಇಮೇಲ್ ಅಲ್ಲಿ ಕಳಿಸಬಹುದು ಅಂತ ಹೇಳಿರುವಂತ ಜಡ್ಜ್ಮೆಂಟ್ ಗಳಿದೆ. ಹಾಗಾಗಿ ಗೋಯಿಂಗ್ ಫಾರ್ವರ್ಡ್ ಇವೆಲ್ಲ ಇಂಪ್ಲಿಮೆಂಟ್ ಆಗುತ್ತೆ. ಹಳೆಯದೆಲ್ಲ ಈ ಟಾಮ್ ಅವೆಲ್ಲ ತೆಗಿಬೇಕು. ಹೊಸ ರೀತಿಯಲ್ಲಿ ನಾವು ಸ್ಪೀಡಿಯಾಗಿ ಸಮನ್ಸ್ ನ ನೋಟಿಸ್ ನ ಸರ್ವ್ ಮಾಡುವಂತದನ್ನ ನಾವು ಬಳಕೆಗೆ ತರಬೇಕು. ಅದಕ್ಕೆ ಕಾನೂನು ಬ್ಯಾಕಪ್ ಕೂಡ ಇರುವಂಗೆ ಮಾಡ್ಬೇಕು. ಈ ಸದ್ಯಕ್ಕೆ ಕೆಲವುದಕ್ಕಿದೆ. ನಾವೇ ಇವಾಗ ಪ್ರಶಾಂತ್ ಚಂದ್ರ ಸರ್ ಒಪ್ಕೋತಾರೆ, ಎಷ್ಟೋ ಸತಿ ಜಡ್ಜಸ್ ವಾಟ್ಸಪ್ ಅಲ್ಲಿ ಕಳಿಸ್ರಿ, ಇಮೇಲ್ ಅಲ್ಲಿ ಕಳಿಸ್ರಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಆಯ್ತಲ್ಲ. ಇದು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ರಿಸ್ಟ್ರಿಕ್ಟ್ ಆದ್ರೆ ಸಾಲಲ್ಲ. ನಾವು ಬರೀ ಹೈಕೋರ್ಟ್ ನ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನ ಮೈಂಡ್ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡು ನಾವು ಯೋಚನೆ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ಮುನ್ಸಿಫ್ ಕೋರ್ಟ್ಸ್ ಯಾವ್ದೋ ಒಂದು ಕೊಳ್ಳೆಗಾಲದಲ್ಲಿ ಇರುವಂತ ಚಿಕ್ಕ ಮುನ್ಸಿಫ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವ ವ್ಯಕ್ತಿ ಇದ್ದಾನೆ ಆ ಕಡೆಯ ವ್ಯಕ್ತಿಗೆ ಅದು ಹೋಗಿ ಸುಲಭವಾಗಿ ತಲುಪಬೇಕು. ಆ ರೀತಿಯಾದಂತ ಅಮೆಂಡ್ಮೆಂಟ್ಸ್ ಆಗ್ಬೇಕು, ಆ ರೀತಿಯಾದಂತ ಚೇಂಜಸ್ ಆಗ್ಬೇಕು. ಅಂದ್ರೆ ನಿಮ್ ಸಿಂಪಲ್ ಆಗಿ ನಿಮ್ ಕೇಳಿದ್ದಕ್ಕೆ 50% ಈಗ ಮಾಡ್ತಾ ಇದೀವಿ. ಅವೆಲ್ಲಾನು ಹೋಗ್ತಾ ಹೋಗ್ತಾ ರೂಢಿಯಲ್ಲಿ ಬರುತ್ತೆ. ಸದ್ಯಕ್ಕೆ ಕಂಪ್ಲೀಟ್ ಆಗಿ 100% ಲೀಗಲ್ ಬ್ಯಾಕಪ್ ಇದೆ, ಲೀಗಲ್ ಸ್ಯಾಂಕ್ಷನ್ ಇದೆ ಅಂತ ಹೇಳಿಕ್ ಬರೋದಿಲ್ಲ. ನಾಳೆ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ಬೋದು. ಅದರ್ ಸೈಡ್ ನಂಗೆ ಬರ್ಲೇ ಇಲ್ಲ, ನಾನು ನೋಡೇ ಇಲ್ಲ, ಆ ಫೋನ್ ನನ್ನ ಹತ್ರ ಇರ್ಲೇ ಇರ್ಲಿಲ್ಲ, ವಾಟ್ಸ್ಆಪ್ ಪಿಕ್ ಬಂದಿರ್ಬೋದು. ದೇ ಕ್ಯಾನ್ ಟೇಕ್ ಅ ಡಿಫರೆಂಟ್ ಡಿಫರೆನ್ಸ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್, ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಅಪೀಲಲ್ಲೇ ಅದೇ ಒಂದು ಕಾರಣದ ಮೇಲೆ ವಜಾ ಆಗ್ಬೋದು. ಹಾಗಾಗಿ ಸೊ ವಾಟ್ ಎವರ್ ವಿ ಡೂ, ನಾವು ಸುಮ್ನೆ ಏನೋ ಒಂದ್ ಮಾಡ್ಬಿಡ್ತೀವಿ, ಸರ್ವಿಸ್ ಮಾಡ್ತೀವಿ ಅನ್ನೋದು ಒಂದೇ ಅಲ್ಲ. ಆಸ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಇಟ್ ಈಸ್ ಅವರ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಟು ಎಸ್ಟಾಬ್ಲಿಷ್ ದಟ್ ಕೇಸ್. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋದ್ರೂ ನೀವು ಅಪೀಲಲ್ಲಿ ಆ ಕಾರಣದಿಂದ ಹೋದ್ರೆ ನಾಳೆ ಬೈಕೊಳ್ಳೋದ ಆ ಮೇಲ್ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ತಪ್ಪು ಮಾಡಿದ್ರು ಅಂತ ನಮ್ಮನ್ನ ಬೈಕೋತೀರಾ. ಸೊ ವಿ ಹ್ಯಾವ್ ಟು ಹ್ಯಾವ್ ಮಲ್ಟಿ ಡೈಮೆನ್ಷನ್ಸ್. ಎಲ್ಲಾ ರೀತಿಯಿಂದ ನಾವು ಯೋಚನೆ ಮಾಡಿ ಅದು ಪ್ರಾಕ್ಟಿಕಲ್ ಆಗೂ ಇರಬೇಕು, ಬೆನಿಫಿಟ್ ಸಿಗ್ಬೇಕು, ಶಾರ್ಟ್ ಟೈಮ್ ಕನ್ಸ್ಯೂಮಿಂಗ್ ಪೀರಿಯಡ್ ಇರಬೇಕು. ಇದು ಮೂರೂ ಬೇಕಾಗುತ್ತೆ. ಈ ಮೂರನ್ನು ಸೇರಿಸಿ ನಾವು ಏನಾದ್ರು ಮುಂದೆ ಮಾಡ್ಬೇಕು. ನಿಮ್ಮ ಪ್ರಶ್ನೆಗೆ 50% ಇದೆ ಅಂತ ಹೇಳ್ಬೋದು.
ಕರೆಂಟ್ ಸ್ಟೇಟಸ್ ಅದ್ರ ಬಗ್ಗೆ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಬಟ್ ಯಾವ್ದು ಕ್ಲಾರಿಟಿ ಇಲ್ಲ, ಫಾಸ್ಟ್ ಆಗಿ ವರ್ಕ್ ಆಗಲ್ಲ ಅಂತ ನೀವ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
ಕರೆಂಟ್ ಸ್ಟೇಟಸ್ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತಲ್ಲ, ಬಟ್ ಇದನ್ನ ಬಳಕೆಯಲ್ಲಿ ನಾವು ತಗೊಳ್ತಾ ಇದೀವಿ. ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಗಳಾಗ್ಬೇಕು. ಲೆಜಿಸ್ಲೇಚರ್ ಇದನ್ನೆಲ್ಲ ತಗೊಂಡು ಗಣನೆಗೆ ತಗೊಂಡು ಒಂದು ಹೊಸ ಕಾನೂನು ಮಾಡಿ CPC CRPC ಇವೆಲ್ಲ ಬದಲಾವಣೆಗಳು ಮಾಡಿದ್ರೆ ಅದು ವರ್ಕ್ ಮಾಡ್ತಿದ್ರೆ ವರ್ಕ್ ಆಗುತ್ತೆ ಅಂತ. ಸದ್ಯಕ್ಕೆ ಕೋರ್ಟ್ಗಳಲ್ಲಿ ಇದೆಲ್ಲ ನಾವು ಚಾಲ್ತಿಯಲ್ಲಿದೆ, ನಾವಂತೂ ಬಳಸ್ತಾ ಇದೀವಿ.
Chetan, I would answer this way. Before you say that WhatsApp or email has to be compulsory treated as a notice, first the government has to ensure that there is technology everywhere, that everyone has the access to mobile or mobility or the email. You should make the law that email is compulsory first. Then only you can say notice of the email is compulsory. How many of them have a mobile? How many of them have WhatsApp in a mobile? So the law also has to develop. Merely, I mean, the technology also has to support. Mere law, making a law, it doesn't help you. We are talking of Bangalore, maybe cream society in the whole of Karnataka, not forget India. We don't know what is the situation in some taluka places. So the law cannot develop beyond a certain limit. It has to depend on the technology also, and therefore it has to depend on the infrastructure, the government. Anyway, thank you very much for the question. Thank you very much for the question. In the nutshell,
Prashanth sir.
Yes, sir, please.
Ankit here. Sorry, I
please.
cannot switch on my camera because I'm in a low network area.
Okay.
I had two questions, and this is just food for thought. Now, when we see that litigations are going from years together, right? Is there a possibility that law authorities are thinking of bringing a cap? Like, for example, under the IBC law, right? There is a cap of 1 year. Within 1 year, you have to finish the cases, right? And there are other sections of the law where they have given a deadline to authorities to close the case. Is there any possibility that there is a deadline which may be set for a criminal or a civil
for
lawsuits
most
also,
of
right?
the laws, I understood your question, Ankit. What you are saying is put a limit, therefore cases get closed faster. I'll come to you, Trivikram. It's a good question. The laws are already there. Certain laws, certain acts provide for disposal of the cases within 6 months, within 3 months, within 1 year. But it is difficult to do it. It's like saying, I'm just giving a different example. Sorry, again, I'm giving a traffic example. I'm in Vijayanagar, I have to reach Soundarya College in 40 minutes. Otherwise, don't go to Soundarya College. I may start off from my house, hoping to reach by 40 minutes. What if there are traffic junctions, because of which I'm not able to reach by 40 minutes to Soundarya College? So can the law be made when the practical aspects are there? The courts are over-flooded. We have certain limitations also. There are many such. I'm just giving an example. There is one law where it says one particular type of case has to be closed in 1 year. But the courts are not able to even do it even after 3-4 years of pendency. Trivikram, over to you.
Ankit, you were mentioning about criminal cases with specific deadlines or time frame. Just go through the part 3 of the Constitution. It says that every accused deserves an expeditious trial, right? And in that context, if you just look at the Supreme Court verdict on the Rajiv Gandhi assassination case, it was reversed only for the fact that assassins were not executed for indefinite time, about 20-25 years. They were kept in the judicial custody without execution. So that itself infringes or takes away your fundamental right. And 138 cases, these check bounce, what we say in normal parlance, the time frame is 3 months. It has to be disposed, maximum 6 months. In 6 months, as I told you, the summons itself will be served in many cases. So in all these cases, what happens is indefinitely it goes. Though there is a fixation of time frame, there could be reality. In reality, there could be problems. Certain problems like what you mentioned, summons, etc. Other problems is you go to Doddaballapur or Devnelli, there are no judges. Every time there is a judge, he is sent to some training, or he is asked to do some other work, or there are no judges at all. What would you expect within 3 months? Those litigants, they have filed cases 4 years, 5 years back. It has not even seen the next stage. All right. So these are practical issues. And how many judges are there? If you take a statistics of the number of presiding officers, it is not even half of it. And 50% of them, they would be deputed on various other administrative and other activities, including working with the government, etc. All right. They are not all judges are made to sit and they are hearing the cases and are disposing. They are given other activities also. So when you look at all these practical scenarios, it's not easy, though there is a time frame. And there are statutes, n number of statutes when it comes to criminal law also, that the trial or the case has to be concluded within so and so period. Even in POCSO cases, just imagine POCSO, it's something pertaining to the child, and the offense is so heinous, and the accused is in judicial custody. Most of the cases, they are not giving bail in POCSO cases. It is taking 3 years, 4 years. The time prescribed is 1 year. You come to CRPC 309, every sessions court case has to be dealt with on regular basis, day and basis. Even today, if suppose the case was today, it should come tomorrow, day after tomorrow, and it should be concluded. You go to any sessions court and show me 5 cases where those cases are dealt in that manner. So I think I've just given you why.
Sorry, go ahead.
Then you will understand what is the practically what are the constraints or impediments for the courts as well as lawyers to get the cases disposed of. These are the practical issues, and you would also say this once you join the bar. Now, as a law student, your understanding and your expectations would be different. But once you come here, it's like you are jumping inside the sea or the swimming pool. From outside, it looks cozy, it looks beautiful, the water. Once you jump, you will know the depth. If it is, if you are shivering, if the water is cold or hot, you will understand only once you jump inside.
To sum up, Mr. Ankit, there is a ratio called as judge litigation ratio in India. The ideal ratio for a judge is 500 cases. One judge, 500 cases. I don't know the recent statistics. I think it is not less than 2,500 to 3,000 cases per judge now. You can't go on increasing the number of judges. The more you increase, more has been the litigation. When I came to bar in 87, probably there were 4 courts dealing with only accident cases in Bangalore, exclusively 4 courts accident compensation cases, tribunals. But Bangalore has grown probably 25 times in the last 30 years. Everyday registration of vehicle is 600 vehicles getting registered in RTO. In that 600, even if you take it as 6 vehicles get accident in the next 5 years, imagine what would be the number of accidents and what would be the number of accident tribunals required. You may increase the judge from 4 to 40, but there is already increase of 600 vehicles per day. So you can't keep that ratio. This is the difficulty which the judges are also finding. Thank you.
Thank you.
Now,
thank you so much, sir. I had one question, last question, sir, if you may.
We'll do one thing. The scheduled break is from 3 to 3:15. We'll just take a break and come back and continue. Now it is
We
exactly
never
3.
started ADR, sir. Section 89. I think we
Ah.
will have to restart from there. Let them take a break for 15 minutes. We'll
Correct.
quickly
We'll
wrap
come
up at
back, take
89 and then
Ankit's, we'll come back by 3:15, take Ankit's question, then ADR, then the rest of the sessions. Okay? Thank you.
Prasad, record start.
So welcome back to session 2 on day 1 of the webinar on ADR, sponsored by the college, Soundarya College of Law and Vakeela Vaahini. In the first session, we had the introduction as to the hierarchy of courts and the procedures before the court. And in the next session, we are going into the alternatives. Before going to that, shall we have the question from Ankit? Ankit, please pose your question. We'll
Yes,
try
sir.
to answer.
Yeah,
Yes.
first of all, thank you very much to you and Vikram sir for answering that question. And
Yes,
as I
sir.
said, it was just a food for a thought, and I do understand the practical issues in complying with the Limitation Act.
Mm.
So thank you for answering that. The next question is a basic question. I just want to understand in which situations can the court go ex parte and pass the order, even if the plaintiff of defendant is not available in the court? Like sir was mentioning, right? Physical presence is required. So I just wanted to understand in which situations can the court go ex parte and just pass the order?
Can we keep it to tomorrow? Because I think tomorrow we may cover this also. In the event
No
it is
problem, sir.
not answered, you can definitely remind me, or Trivikram, we will definitely answer.
Sure, sir. Sure. Thank you so much.
So answer is there. Only thing is, we are trying to see that it is structured in such a way that this is also answered later.
No issues, sir. No issues. Thank you.
Okay. Trivikram, please proceed.
Okay, sir. Thank you, Ankit, for your question. We were not trying to stop you from asking. It's just that we were trying to say what is the reality. We are more than happy when questions are asked. The very intent is, the purpose will be served when students are interactive. We feel very good. And sir, can we start with section 89, sir? Yes. In the first session or in the first part of our discussion, what we were trying to discuss is more of procedures and what is cumbersome and what is time consuming, what is costly. All right. We are not trying to say that you should not come to courts, don't come. The procedures are stringent or it is time consuming. That's not the intent. The whole intent is it should be very simple, and how when you take a gadget, it should be what you expect is the gadget should be user friendly. The same way, court should be friendly to the litigants. What is friendly? You should get relief in a timely manner, right? With the same intent or with the same discussions before 1999 by the then legislatures, the able leadership of Mr. Atal Bihari Vajpayee, they tried to bring some amendments to CPC. Especially what is noteworthy is section 89, what has been amended or what is some changes were brought in. If all of you, what I request is take a bare act and check what section 89 of CPC reads as. All right, very simple. I would request everybody to at least open CPC. If not, if you don't have a bare act, at least Google it and check. Because when we are saying something, you should be on the same page. All right, only then it makes sense, and you would also have clarity of what we are discussing about. See, this comes under part 4 of CPC. The main heading is special proceedings. Settlement of disputes outside the court. Such a wonderful concept. They don't say that outside the court means don't come to court. That is not the intent. But making use of the available resources like the advocate or the courts, including them, you make an effort to get your case disposed by alternative methods. What are these alternative methods? That is the main agenda or topic of discussion in this workshop, which Prashanth Chandra sir, who is a master trainer, he would touch and he would give you more clarity as to what This topic is how it could be dealt, how it is used, and how it is beneficial over a period of 2 decades, more than 2 decades. Here, what I'm trying to only convey is this amendment was brought way back in 1999. And just imagine, when is our CPC brought into effect? CPC is brought into effect in the years 1909 or 1908. All right. So it has taken almost, say, 90 years for bringing some changes. In this 90 years, what the legislators and the people in this fraternity, what they had experienced is a lot of time-consuming factor. There are certain procedures which the court cannot deviate, court should follow. And by virtue of all this, there could be a delay in the case. Instead, to adopt these 4 methods of arbitration, conciliation, mediation, judicial settlement, including settlement through Lok Adalat. So what is Lok Adalat? What is arbitration? What is mediation? What is conciliation? It's almost similar with a thin line of difference, which would be dealt with Prashanth Chandra. But here, if you have just gone through the newspaper reports of yesterday and day before yesterday, you would have seen that about approximately 8 lakh cases were disposed by the Karnataka judiciary. In one day, that is Saturday, 3-4 days ago, about 8 lakh cases were disposed in one single day on Lok Adalat day. Right? On this day, 8 lakh cases were disposed. I'm repeating it for your benefit. You have overheard it and thought 8,000 or 8 cases. No, 8 lakh cases. And Honorable Justice U. Lalit made a mention that about 95 lakh cases were disposed of in that Lok Adalat. Just imagine, with the population and with the trend of litigation that we are facing. The trend, why I mentioned use the word trend is, for every simple thing we file litigations. Cases which are filed every day, the statistics are big. All right. So 95 lakh cases were disposed in one day throughout the country. This could happen only because of introduction of Section 89. And all these cases, more or less, they have got reliefs. What are these cases which were disposed of? For example, one simple check bounce case where the litigation subject matter is 1 lakh. There's a check which was given for 75,000, 1 lakh, 25,000. For this, you will have to wait for 10 years, 20 years. Instead, the parties are agreeing, either one party will say, I'll pay only 50,000 instead of 60,000. Other party will say, I'm okay with that. They take that money, they're happy. It's the husband and wife who have at least filed 8 to 10 litigations, they got their cases disposed. Either they got reunion or they have resorted for divorce. The children are also happy because they have got some kind of clarity whether they will stay with the father or mother, or they'll stay together, etc. All these varieties of cases, even in civil disputes, variety of civil disputes, is beneficial to the litigant and court also to some extent. And administrative, when we think from the administrative point of view, every cases that gets listed before the court, government exchequer is shelling out a lot of money every day. Every court hall, every judge, every stenographer, every printer is coming from the taxpayers' money. And you're saving all that. And parties are also happy, they're beneficial. So this is the whole agenda, to reduce the time frame, give the relief as far as possible in the cases which the law provides such a mechanism. It cannot be dealt with in every case. For example, there's a murder which has taken place. You can't get into a settlement. That's why there's a distinction between justice and equity. In your prayer, the criminal case, you ask only in the interest of justice. In a civil case, you ask equity and justice. That equity can be brought. Both of you can be treated equal. One person has to get 50,000 and he has got 50,000, that equity or justice is done. A dead person, the family cannot get him back. So these cases cannot be solved through mediation, or even if they want to. For example, in a rape case, most of the times they come and say they want to settle, they want to remarry, etc. It is not possible. In one or two cases, exceptional cases, High Court or Supreme Court might have agreed. The Supreme Court came heavily upon even the High Courts when they tried to use these settlements. They cannot compound it. They cannot cause, because the accused says that I will marry the victim, I will reunion, I will take care of her. That can't be done. So what I'm trying to convey is, there are certain cases where this can be implemented, a certain case where this concept cannot be implemented. But by and large, for a litigant, the introduction of section 89 has been very beneficial. And even I have not touched about the commercial courts or the commercial transactions, where two giant companies, they are just their focus should be on the business. Instead, if they get deviated to litigation, they are wasting time, energy, etc. All this can be mitigated, and both the parties can be benefited by adopting alternative dispute resolution mechanisms. This is about section 89, and I would request all of you to ask some questions. Even if you don't have, I want other students to ask questions. Even if you don't have, you should ensure that you have asked something. Iram, Venkat Lakshmi, Vishnupriya, I'm just mentioning few names. But I want interaction. Every student should interact with us. See, we know now about Ankit or Anbu, Gokul, etc., because they came on video and they interacted with us. Same way, we want every student to interact. By the end of this 2-day workshop, we should be able to know each other better. Sir, is there anything that you want to add?
I will add. Let questions be there if it is there. I don't think. Shall we continue? Shall I continue?
We will impose some costs on them if they are not.
Correct.
One question.
Yes, sir.
Yes.
See, one criminal case as well as civil case clubbed. In that point type, what we have to decide and how we have to approach the court and judge.
We will answer it tomorrow. It's a valid question, Tippeswamy. You are saying a civil case and a criminal case, can it be clubbed and can it be approached together?
Correct.
And I would say it also can be referred to one of the ADRs, and even it could be resolved. What is that nature of case? We'll deal it tomorrow. We are having some session on that. Thank you.
Okay.
Any other questions? Kiran, please open your camera. Yes, Kiran. Any question? Good afternoon.
Sir, I just had a doubt. Sir, according to me, my thoughts about ADR were that I always felt that we cannot approach for a criminal case to ADR. This is my basic knowledge because I've not learned much about it. So if,
you are right. You are right. Answer is right. Yes, but I will let you know immediately after this. Why?
Yes.
Trivikram has already dealt with it. I'll also answer that.
Sure, sir.
Any other question, Kiran?
No, sir.
Okay. Shall I take over, Trivikram?
Yes, sir. Yes.
Okay. See, firstly, section 89 CPC. We are dealing with the alternative, and the question is about what are those alternatives? What is this section 89? Hopefully, you're all having your books in hand, as Trivikram put it to you. Section 89 is an amendment in Civil Procedure Code. Note it. It is not in Criminal Procedure Code. It's a procedure where, in a normal civil court case, the court, with the assistance of the parties and the respective advocates, may employ section 89 to see whether the parties can be referred to any one of those mechanisms which are recognized therein. So answering the question of Kiran straight away, it is an amendment to civil procedure, therefore it is not an amendment to criminal procedure. Secondly, in 89, what does it deal is settlement of disputes, settlement of civil disputes. It can be resolved in mediation or other mechanisms in 89 because it's all private disputes, civil disputes between the parties. Please note, murder, rape, POXO cases, they are all offense to the state. Though the individual affected is an individual finally, it's an offense to the state. It cannot be mediated or resolved in section 89. Accident, rash and negligent driving, section 279, 337 or 338, grievous injury. It cannot be compensated by asking the driver to pay some penalty. I'm sorry, pay some settlement money to the party. Insurance takes care of the accident case compensation. That's a different thing. They're all offense to the state. Therefore, please note section 89 is dealing with civil disputes only. However, there is a rider, which I would answer because Tippeswamy's question is, how can we have the criminal and civil together and have a solution in there? That we'll deal it tomorrow. So therefore, what we started in the morning, yes, Trivikram?
I just wanted to ask him to read section 320 of CRPC, so his question will be answered.
Yes. Yes. Tippeswamy, please note on 320 CRPC.
Thank you, sir.
Okay.
And one more question. Sorry for,
Yes,
I think you are in between
Heading,
to
please.
convey the. Nowadays, court judgments are very delayed. So, if the culprit is asking the justice, it will be delay for, time gap. So, what is the measures is, court of law and, authority of law is going to take to reduce it?
You just entered the veranda of the house. You're already in the dining room.
Yeah.
We'll come to the dining room tomorrow.
Okay.
We have just entered the house. We have just crossed the compound and entered their veranda. Your question will be answered. Trivikram will definitely answer it tomorrow. Thank you for that question.
Yeah.
So coming back to the subject, we started today with Hegde saying about the hierarchy of court, where he refers to criminal cases also and sessions cases also. As we went further, when Trivikram gave an example, it was referred to a civil case. As we go further, it is only civil cases, because when we talk of section 89, it is actually civil disputes, not the criminal cases. Number one. Secondly, thanks to section 89, which was amended in the year 99, which was brought into effect from 1/7/2002. Incidentally, it is 20 years today. We have to celebrate the 20th year of the ADR. Thanks to that ADR, exactly today, 20 years back, the parliament brought in this amendment and it was brought into force. If I am sitting before you, if we from Trivikram, Dr. Hegde, Mr. Ramakrishna, we are all sitting before you to discuss, thanks to section 89. If section 89 was not introduced, probably we would not have met you at all. We had no occasion to meet you at all. So what is this 89? There is already an existing system. That system is already crowded. The courts are not able to deliver justice at quick time. Therefore, there has to be a thinking to see whether there are any alternatives to the system. So therefore, section 89 introduced 5 alternatives. Please note, this is in addition to the existing one. That is the civil procedure code or the civil procedure dispute resolution mechanism. What Trivikram gave you in 45 minutes as to how difficult it is to get justice in the existing system. The procedural lapses, procedural hurdles which we face in a civil dispute. So the purpose of section 89 is to see, being already in the system, you having already filed an existing case, the opposite side having been already notified, he having already come into the case, Both parties being already in the court system, the judge or the advocate or the parties may at any time ask the judge to refer their disputes to any one of these mechanisms, namely arbitration, conciliation, Lok Adalat or Legal Services Authorities Act. It is popularly called as Lok Adalat, mediation, and judicial settlement. When we say arbitration, it is under the Arbitration and Conciliation Act of 1996. When we say conciliation, it is again under the Arbitration and Conciliation Act of 1996. When we say Lok Adalat, it is under the Legal Services Authorities Act. When we say mediation, it is under the mediation rules. There is no mediation act yet. There is going to be a mediation act shortly. When you say judicial settlement, it is not still explored. It's still unexplored. It is still vacuum insofar as judicial settlement is concerned. We are not clear as to what is a judicial settlement, because in one of the judgments of the Supreme Court, they have said a particular case could be an example of judicial settlement. So we'll, for the time being, we'll ignore judicial settlement and deal with the remaining ones, namely arbitration, conciliation, Lok Adalat, and mediation from now onwards till tomorrow 4 o'clock. Now I'll come to arbitration. This session is dedicated to arbitration. This session I'll deal with as to what is that arbitration, who is an arbitrator, why an arbitration, what does the arbitration do, what is the effect of that, what is the benefit of that, what is the demerit of that, and what is the finality to that. Please note, when I say arbitration, you may think it is Arbitration and Conciliation Act 1996, which means to say it has come into effect only about 25 years back. No. Arbitration is in our system from time immemorial. It may not have been called as arbitration. It was called as regulations, panchayats, panchayatdars. They were also arbitrators. In any dispute in a village, if this village head wanted to take a decision, the villagers were going to him and saying, "Sir, we want you to take a decision." And he used to operate as an arbitrator, though he was not called as an arbitrator, he was called as a panchayatdar. Usually 5 people used to sit, the senior most matured people of the village. They used to say, okay, this is right, this is wrong, therefore do this or don't do this. Follow it. We are telling you, you follow it. That was arbitration. Later on, as the society grew, there were some demerits of that system. To overcome, there was an act, and that act was called as the Arbitration Act of 1940. The Arbitration Act of 1940 was only dealing with arbitration. Later, in the year 1996, it was amended as the Arbitration Act, Arbitration and the Conciliation Act 1996. So it is this Arbitration and Conciliation Act of 1996 is that what we are dealing now in the next 30 minutes. When I say Arbitration and Conciliation Act 1996, please also note down. These are all your answers for your questions if it comes to you on ADR. Though it came in the year 1996, it has already seen 2 major amendments in the year 2015 and 2019. So the Parent Act or the Mother Act is 1996. There are already 2 amendments, major amendments in the year 2015 and 2019. The whole idea of the parliament is to see that people opt for arbitration and get quicker relief and faster justice. Therefore, they have tried to strengthen by giving new amendments, additional teeth to the arbitrator by introducing the amendments in 2015 and 2019. The amendments are called The act is called as 26 of 1996. Then the two amendments have come. One in 2015, and the amendment which has come in 2019 is called as 33 of 2019, which has come into effect from 9/8/2019. So what is this arbitration? Arbitration is a place where two of the parties to a dispute, before even the dispute emerged, enter into an understanding between themselves where they agree that in the event of a dispute between us, it may happen, it may not happen, but in the event of a dispute, we will agree to refer the dispute to an arbitrator. That is to say, the two individuals, it could be a company, it could be two individuals, it could be a different set of people, it could be a society, or society and individual, company and individual. They say, we will hereafter enter into a trade agreement or a agreement between ourselves. We also agree that in the event of a dispute between us, we refer our dispute to arbitration and not court. That word is important. They themselves, by consent, expel themselves from the court. In other words, they say that in the event of a dispute, let us not go to the court, let us resolve through an arbitrator. It can be a part of the wholesome agreement, which contains various other clauses. For example, distribution agreement, franchise agreement between the two individuals with a clause on arbitration. Or it could be exclusive sole clause of arbitration. No other understanding. In the event of a dispute between me and so, we hereby agree that we will opt for arbitration. So that is that arbitration. In other words, they are saying, in the event of a dispute, we will agree to refer this to a court, not to the civil court. Please note, all that will be a civil dispute otherwise. Hegde told you, civil judge junior division, civil judge senior division, district court. This is not that. You are deviating. You are finding your own court. Namely, it is called as arbitration tribunal. You are making your own judge. He is called as an arbitrator. You choose your judge. You choose your court. You choose your procedure. You choose your method of proceedings. You decide. Agree to agree, agree to disagree. It's such a beautiful concept. In other words, I would say arbitration is nothing but privatization of the courts. Please note, 1940 itself, our parliamentarians or our previous parliamentarians have thought about this concept, because we got independence only in 1947. Such a simple method. I have a dispute. I know the courts are probably not able to resolve it immediately. Maybe our dispute is pertaining to commercial law, where the commercial trade is affected, industry is affected, business is affected. Therefore, we'll have to find an alternative mechanism. Therefore, we'll opt for arbitration. We choose X as our judge. I choose Trivikram as my judge. Ambu is my opponent. She also says, yes, I choose Trivikram. Trivikram is appointed as the arbitrator. So arbitral tribunal consisting of Trivikram will be the sole arbitrator. Please note SOUL. It is not SOUL, it is SOLE. Sole arbitrator. Of course, Trivikram also can be a sole arbitrator. SOUL. Such a beautiful thing. I agree to disagree with Ambu. I also, in the meantime, agree to go to arbitration, resolve it in a gentleman manner before Trivikram. Or it could be the other way. Ambu says, no, no, sir, you have brought Trivikram. He is your Vakeela Vaahini friend. I don't want to trust only one person. Let us have one more person. I will suggest Dr. Mahesh. Okay. I choose Trivikram. Ambu chooses Dr. Mahesh. But arbitrator tribunal cannot have two persons. It has to be three, which means Trivikram and Dr. Mahesh will agree and appoint one more person. Will agree Dr. Shobha Rani madam as the three-person constituted arbitral tribunal. Ambu is very happy because two persons from Soundarya are with me. They will give judgment in my favor. Please note, odd numbers only matter in arbitration. The tribunal consisting of sole arbitrator or 3, 5, 7 like that. It cannot be 2, 4, 6, 8. So in other words, arbitrator is a private judge who is appointed by the consent of the parties. And the parties agreed that they will abide by the judgment given by the arbitrators. We'll accept it. If we are very aggrieved or unhappy with the judgment, we agree to go to the next level. Failing which, we'll accept the judgment, we'll follow what they observe it, what they direct us. Procedures. Place is all the choice of the parties. It could be that, Trivikram says, no, I will not come to Soundarya College. Please come to my house. I'll provide you the hall. We'll have arbitration in our house. If I agree, Ambu agrees, Dr. Mahesh agrees, Shobha Rani madam agrees, that can be the place. So the place of arbitration is our choice. Okay, of course, with again the consent of all the stakeholders. Suppose Dr. Mahesh says, no. Why should we come to Trivikram's place? You come to my place. I'll give you Soundarya entire paradigm, building. We'll have arbitration there. Trivikram agrees, so that can be the place of arbitration. All of us should agree. That's all what is required. It could be that we are sitting in Soundarya College for arbitration because the tribunal of the arbitration is at the seat of Soundarya College. But it could be that a dispute pertaining to Tumkur is referred there. I'm just giving an example. The witness to be examined probably is to come all the way from Tumkur to Bangalore. So the arbitrators may say and the parties may say, sir, the next sitting, let us have it in Tumkur instead of Soundarya College. That's also possible. So by the consent of the parties, the seat of the arbitration can also be changed from whichever place they want to. They can be in Soundarya College, it can be in Tumkur, or it can be in Ooty, Darjeeling, or even America. Procedure. Trivikram told you the procedures before a civil court. How difficult it is to get a notice. Survey notice. How difficult it is to catch hold of a policeman to get the notice served. Or the Amina of the court. Amina means the server of the process server, we call it, or the spune of the court. I can't summon Anbu directly. I cannot go to her and say, Madam, please appear before court. It has to be through the court process, namely the postal sources or the court Amina, we call it. To avoid that, in arbitration, it can be by a different process where the parties agree themselves. Or sometimes both would have come to that level. Therefore, there is no need of again issuing of a notice. By consent, they would have agreed to come before one common forum. Trivikram, for want of time, has not dealt with the evidence process in the court. Sometimes examination, cross-examination of witness takes months, years. Because I am ready, Anbu is not ready. Ambu is ready. I am not free on that day. Both of us are ready. My advocate Ankit is not ready. Ankit is ready. Anbu's advocate is not ready. All of us are ready. Judge is not free. Because of that, cases get delayed. But in arbitration, it is exclusively one court, one case, which means we all agreed to go to arbitration center at Soundarya College on 2nd of July 2022. We all go there at 10:30. Arbitration starts exclusively for this dispute between me and Ambu, and the matter is taken up. No other case to disturb our case. It goes on, and in probably 1 hour, we will make substantial progress as compared to a civil court. Please note, in a civil court, there are 100 cases in which your case is also one. They put a list. I don't know how many of you have gone to the civil court. You would have seen a list. Yes, thank you. You would have seen a list. Your case will be probably at the last. You'll be wondering why my case is always at the last. How do I see that my case is taken up at priority? So the judge in the 5 hours of that day has to give equal time to all of them, including you. Whereas in arbitration, all the 5 hours is for you only. See the amount of progress it makes in a day. So it's such a simple process. It takes care of the appointment. It takes care of the premises where the arbitration has to be held. It takes care of the process. It takes care of the secretarial services. Maybe it requires some recording of evidence, some other procedures, or maybe recording of the oral arguments. Everything is provided in an arbitration center. If the infrastructure is already there with the arbitration center. Soundarya can be a good arbitration center. Why not? As long as the two parties come, it is possible. You can dispense with certain procedures which otherwise, take years in a court. I am producing this document. It's a book. I'm just giving an example. It's a book. I am producing this document. In a civil court, I need to do it in a particular manner. I had to take permission from the judge. I had to take permission from my opponent. Then I had to produce it. Then she will have to look at it. Then she may say, no, I don't accept this. That means different procedure altogether. Whereas in arbitration, it can be, I just ask Ambu, Madam Ambu, this is what I want to produce. I don't think you would have any serious objection. This is only this. She may say, oh, it's okay, sir, no problem. We have a serious dispute, but no serious dispute at all regarding this document. It gets marked. It gets considered by the arbitrator. So the procedures are also simple. Sometimes we are asked to produce driving license, passport, which means you have to produce the original. In a civil case, you have to produce the original. Maybe, who knows, Ambu is going abroad for Singapore next week, but her passport is stuck here. The concept of photocopy is not there in a civil procedure. Even if it is there, it has another procedure to follow for it. You can't simply say, no, I'm not producing original. I'm going abroad, therefore take my photocopy. But in arbitration, it can be only the photocopy for which Ambu may say, I have no objection, because finally, Ambu is producing it, so I may have no objection. After all, I know that she has a passport, she is going, but that has nothing to do with my serious dispute about my amount, my claim. So the procedures get reduced. Then argument. In a court, some of you are here who are lawyers, so they, when you get ready and go to the court, the day when you are ready, the judge will not be ready. When you are not ready, the judge will be ready. This is a common phenomenon, we have it. In arbitration, it can be orally done, it can be recorded and sent, It can be sent by writing, or sometimes who knows, the judge, because it's an exclusive judge who is dealing with it. He himself may say, Miss Ambu, I know your case. You are saying A, B, C, D, E, F. Have I understood you rightly? Yes. Then only tell me about X. I have not understood what you're saying about X. If you answer X, then I think I'll be ready to pass the judgment. So you need not have to start from A. You can directly go to X. Then you will say Y and Z and say, okay, day after tomorrow, I'll give you the award. That is called as a judgment. Please note, there is no difference between award and judgment. It is a word used separately in arbitration. So in short, arbitration is a privatization of the court, where you have the parties by consent appointing an arbitrator to resolve their dispute at the earliest. See the contrast. That's why we started with that, and then we introduced this subject. What would be the time, the mental agony a client goes through just to, get a summon served, get to the stage of issues. Trivikram jumped from issues to judgment. Issues itself will take 5 years in a court. Forget judgment. Judge has no time. Thereafter, there will be substantial progress. Issues probably is 20% of the progress. Thereafter on, the real battle starts in a court. Here, all that is avoided, and by a consent, it can be that an Ambu says, sir, my exact dispute is only is X. You are saying X is not X, it's X plus 1. So the arbitrator will have to only decide whether it is X or X plus 1. A2, so far, no doubt, no dispute, only X. He says, she says X is X. I say X is not X, it is X plus 1. Arbitrator will straight away go to that point and say, according to me, it is X, or according to me, it is X plus 1. He will decide it. It is as simple as that. So in short, contrast to the civil procedures, arbitration is a procedure where the parties eliminate, number one, the delays, the procedural inconveniences, and very importantly, they choose their judge. In a system, I have no choice. If I have to file a case in Tumkur, it has to be in Tumkur only. It cannot be in Mandya. It cannot be in Ranchi. Maybe today I'm in Ranchi. I can't come to Tumkur. I have no choice, but I have to go because territorial jurisdiction. Arbitration can be in Ranchi, it can be in Tumkur, it can be in Mandya, it can be in Singapore. Sometimes it could be a judge. I don't want to continue my case before a judge for whatever reasons. Maybe I am prejudiced, or maybe he is not according to me competent, or whatever, because he's a system, he has come from the system, he is selected from the system. I have no other go but to continue. But here, you have chosen the judge. You feel that he is competent. So Ambu feels that Dr. Mahesh and Shobha Rani are competent. And with Trivikram, who also is a competent man, maybe I'll get justice. That removes so many of the barriers which otherwise come before a mind of a litigant. He's open to dialogue. He's open to litigate. So you have the judge, you have the place, you have the procedures, you have the judgment, all privatized. If the judgment is given, it is called as an award, I said. Then there is also scope for appeal. It is called as section 34. An application can be filed. It is called as an application, but it is actually appeal. But Please note the grounds of appeal are very limited. I can't say trivial reasons. For trivial reasons, I can't say I am aggrieved by the order and I want a appeal to be filed. Or even such appeal is filed, the court may say, according to me, there is no trivial, there is no such serious reasons. It is not a reason for changing the judgment. Please accept the judgment. I'll confirm the judgment. I'll just give an example. Ambu has a doubt. She wants to know whether 2 plus 2 is 4. If so, please decide. That's a dispute before arbitration. I have a serious disagreement with Ambu. I say 2 plus 2 is 3. It is not 4. So according to her, it is 4. According to me, it is 3. We want the arbitrator to decide. I expect the arbitrator to decide as 3. She expects that the arbitrator decides it as 4. We both submit ourselves, we participate, we go ahead. We may sometimes skip the evidence because it's all a matter of mathematics. 2 plus 2 is 4 or 2 plus 2 is 3 is a mathematics. So we may straight away argue the case. Go into the argument and finish it in 3 months, 6 months. We'll assume the judge says 2 plus 2 according to me is 5. Ambu feels, no, it was 4. She may go to the higher court and say, arbitrator has not understood law. He doesn't know mathematics. Please set aside the judgment. Please set aside the award. Make it 2 plus 2 is 4. I may also go saying that 2 plus 2 is 3. Arbitrator has not even said 4. He has gone to 5. It is totally erroneous. Opposed to public policy. Please note the ground of attack could be only opposed to public policy under section 34. The judge sitting under section 34 may say, Mr. Prashanth Chandra, according to you, it is 2 plus 2 is 3. According to Ambu, it is 2 plus 2 is 4. But arbitrator is a man also of sound mind with a judicial application, may be an expert in the field. And according to him, 2 plus 2 is 5 for some reason, we'll accept it. It is not a serious error. According to him, it is correct. Instead, if the arbitrator had said that 2 plus 2 is 50, the judge may say, I think the arbitrator has made a serious error. He is not saying 5, he is not saying 3, or he is not saying 4. Maybe there is some error in his calculation. We'll set aside the judgment award. So the ground of attack in the arbitration should be very serious one so as to go and challenge it in the next level. It cannot be a frivolous ground as we usually do in a civil appeals. Same were to be done by a civil judge in a civil court, 2 plus 2 is 5. It's a very serious error. Who knows if the judge in the next level, appeal level, may even say, recommend the suspension of the judge for having said that 2 plus 2 is 5. Not only judgment is wrong, we'll take action against him because he's not understood law at all. He doesn't know mathematics at all. So where does it apply? Arbitration. Any dispute pertaining to commercial transaction. Landlord-tenant dispute. Disputes pertaining to construction. Disputes pertaining to contractor and owner. Disputes pertaining to asphalting. Whether the thickness of the material used for asphalting is right or wrong. Probably you have watched yesterday's TV or news. Our Chief Justice has said that the BBMP has not put quality material. We'll assume BBMP is also seriously having a dispute with the contractor who has put the material. They would have told him, you put 5 inches, you would have put 3 inches. I and you will not understand whether 3 inch or 5 inches, how is it measured? It is not just go and tape, measure it. It has its own combination. It has to be asphalt mix of what you call black tar, then jelly, cement, etc. It requires an engineer. He may say after examination, maybe physical inspection of the place also, he may say, no, the engineer, contractor has not put 5 inches. He has not put this ratio. Asphalt has to be 50%. Jelly has to be 30%. It is not in that ratio. Therefore, the contract work is poor. So such disputes where it requires expertise, where it requires some person with experience to speak, arbitration is ideal. Where the matter requires a quick hearing, faster approach, where the money is required for faster circulation among the people because money is blocked in a dispute, arbitration is ideal. Landlord and tenant, they agree in the agreement itself. They have a lease agreement. I continue to be tenant for 20 years. In the event of a dispute, I agree to have a dispute, refer to arbitration. It could be an arbitration dispute. Medical negligence between a patient and a doctor, serious dispute about the doctor having made a medical negligence. It could be a third party, namely a senior medical doctor who could be an arbitrator. Whether the quality of construction is appropriate or not, whether he has used the right combination. It could be a structural engineer who can be an arbitrator, or it could be an architect who could be an arbitrator. So arbitration is a specialized subject of law where it tries to reduce the burden on the existing judicial system by outsourcing of them to the civil, from the civil court to exclusively to the arbitrator, who does the job of a civil judge outside the court system. The civil court under Section 989 outsources the dispute to the parties to go before arbitration, and the parties refer their dispute to a competent man, a man with comprehensive knowledge on the subject, or even without knowledge. Sometimes a man with abundant experience can also handle it. It need not be that he has to be always competent. Subject expert, domain expert, we call it. That's arbitration. Or it could be combination of one legal person, one technical person, or two technical persons, because it has to be 3 persons always. So it can be 2 technical persons, one with legal man. Why they choose a legal man is that is usually a retired judge or an advocate, senior advocate, is because he has the control over the procedures. A technical engineer sometimes may lack that knowledge or experience, and he may not be able to control the procedures or expedite the process. Whereas if it is a man with legal backing, he would be able to do it. It is not that, all the time it has to be a retired judge or an advocate. It can be anybody. So gentlemen and ladies, I can go on and go on. We'll deal it again tomorrow when it comes to it. It's now time for questions. Yes, Ambu.
Sir, I have one doubt, sir.
Please, please.
If we both of them decided on arbitrator, in between, in middle, I feel like that arbitrator is only partial with you. Then I can't, the middle way, I can change the arbitrator.
Yes,
sir.
you are entitled to. Good question. You are entitled to change. You choose a judge whom you thought is neutral, whom you thought is having integrity or the competency. You may find that he is not so. You may ask for change of the arbitrator. Substitute arbitrator, we call it. Thank you.
Thank you so much, sir.
Yes. I am not quoting the law. All that is for you to study. I can simply say section 15, 14 and all that. I want you to read that. Any other questions? Ramya L. Nayana. Shweta, you had some question? Please note, I'm not giving you a lecture on the subject. Lecture is always there from your college. I'm trying to give you the concept. First, understand the concept. Then we'll all understand the other nuances. how to go to arbitration. What if one of the party does not consent for the arbitration? You can ask me a question, I'll answer, but otherwise we can always look into it in the sections. Let us understand the process. This process is something very different from the litigation process. There, the choice for the party is very limited. Like Trivikram put it, Ramappa, likes it or not, he has to be all the time on his advocates and on the court to see that he gets justice. He has no say, unfortunately. Poor litigant means, I'm not saying poor by means, unfortunate litigant who has no say in this matter at all. It's his advocate and the judges who decide his fate. Whereas in arbitration, the litigant chooses the judge, litigant chooses the process, litigant chooses the methodology, place, and expediting is also in his hands. So from a system where I have no choice, or I would say from a system which is very formal, this is a sort of an informal process where the litigant stakeholder is given some prominence by the alternative method.
One question.
Please.
In matter when there is an eviction suit decided to be filed, but there is no clause of arbitration clause in the rental agreement. But due to the court procedure, the clients or the parties decide to go for arbitration. Later, when they can they make an arbitration agreement and say that they would be binding to the award?
Good
Can
question.
that be the
Good
situation,
question.
sir?
Shweta, thank you for prompting me. Her question is this. Parties have not entered into an arbitration agreement. Parties are already in the relationship, landlord, tenant, whatever it is, distributor, purchaser, manufacturer, seller, whatever agreement. They did not think of the arbitration or the clause of arbitration. Question is, can it be referred to arbitration? Answer is yes. The consent to arbitration need not be only by an agreement. It can be even post agreement. Anytime before, they both think of it. I'll take the same example of Ambu and me having a dispute, but there is no arbitration clause, pre-arbitration clause. Now, there is a dispute. I make a claim against Ambu saying that 2 + 2 is 3. Please agree. She says, Mr. Prashanth Chandra, I respectfully disagree that 2 + 2 is 3. According to me, is 2 + 2 is 4. I will not give you the money. Dispute is created now. Then I can again say, or she can ask me, Mr. So-and-so, now that we have a serious dispute, shall we opt for arbitration? At that stage also, by consent of the two parties, it can go for arbitration. Anytime it can go to arbitration. It can be by SMS communication. It can be by telex. Of course, now I think nobody uses telex and all that. Telegram, I don't think PNT has stopped the service of Telegram, I think, after this SMS and other things. But still, communication has to be made and it has to be accepted. If I say, Ambu, will you agree? She says, yes, arbitration is constituted. Tribunal is constituted. One more thing that reminds me, Shweta. No agreement. Parties have, that is to say, I am the plaintiff. I have already filed a civil suit. There is no arbitration clause. I have filed a suit saying that 2 + 2 is 3. There is a serious dispute between me and Ambu on as to what is 2 + 2 means. I have already filed a civil suit. I have paid, say, 1 lakh rupees court fee also on that claim. Ambu appears in the civil court. She files the written statement where she still says no, 2 + 2 is 4. Dispute is now created. Judge can say, Mr. Prashanth, Madam Ambu, do you want the case to continue here? Do you want to opt for arbitration now? There also it can be done. That is section 89A. So in other words, section 89A can also refer any dispute to arbitration. Need not be that arbitral disputes which are already there only has to be referred to arbitration. Even a non-arbitral clause dispute also can be referred to arbitration by a court by consent of the two parties. That's why I use the word outsourcing. It can outsource, simply pluck the file and say, please go to arbitration. Thank you very much. You have reduced my time. You have saved my time rather. As I said to, I think, Ankit, one judge, the ideal ratio is 500 cases. If the judge has 5,000 cases, remaining 4,500 cases, he has to do only outsourcing. He can't handle all the 5,000 cases in his file. He needs to look at the different ones, mechanisms. Any more questions? Otherwise, I'll go to the next one because I'm not completing the entire subject. There are so many questions which may be posed. We'll still answer it tomorrow. I'm just introducing the concept and going to one, trying to say what is the difference between the existing system and what is this alternative about. Because you should not think that what is arbitration, what is concession, is all the same. Different words, different, what you call, spellings. No, each has its own purpose. What cannot be done in arbitration can be done in some other mechanism. What cannot be done there probably can be done in arbitration. To sum up, arbitration is also an adjudicative process. Please note, civil court also decides the rights of the parties. Ambu is wrong, Prashanth is wrong, I am right. 2 + 2 is 5 is the judgment of the civil court. Same is the case with arbitrator also. But the difference is that is a public forum. This is a private forum. That's a court. This is a private court. People keep asking when we travel or when we meet somebody, when we go to functions, receptions, can we not privatize the courts? Insurance has become privatized. Transport has become privatized. Air travel has become privatized. Everything is privatized. Why not the courts? Please note, our parliamentarians have thought about it even 100 years back. Privatization, we have not understood so far. Arbitration is nothing but privatization. You do whatever you want. If you have a serious dispute, then only come after the award. Then only the court takes care. I would not like to read, but I'm just reading. The objective of the act is also that less intervention by the court. The word used in the objective of the act is, please look at it tomorrow also, we can discuss further. Less intervention by the court. See, here the judges are, the law is saying, parliamentarians saying, you find your own source of arbitration. Don't disturb the courts. If you have a serious dispute, come to the court then only, not otherwise. Any other questions? Because I'll have to cover Adalat also, that is to say Legal Service Authority, in the next 40 minutes. Then rest of it, we'll take it up tomorrow. So to answer, arbitration is an alternative mechanism recognized by the civil court, where the court can also refer the matter to arbitration for adjudication of the dispute. Earlier it was not. Only by the amendment it was made as an alternative. Please note, arbitration is of the year 1996. The act is of the year 1996. Forget 1940, 1996. The CPC amendment is in the year 2002. Only in 2002, for the first time, the courts have recognized the arbitration as an alternative. Earlier to that, it was not recognized, which means a judge can always ask the parties and refer the matter to arbitration and try to give quicker justice to the parties by asking them to approach the arbitration. One way of reducing the burden. Now we'll go to Lok Adalat, or it is called as Legal Services Authorities Act. the Legal Services Authorities Act provide for two things: Lok Adalat and permanent Lok Adalat. Please note, Lok Adalat is not permanent. Permanent Lok Adalat is permanent. There is difference between the two. Chapter 6A of the Legal Services Authority provides for permanent Lok Adalat. Up to chapter 6, it provides for Lok Adalat. So permanent Lok Adalat under chapter 6A provides for certain public utilities to be the disputes before it, which can be tried as a pre-litigation dispute. Section 22A definition, it gives pre-litigation conciliation and settlement. Chapter 6A, Roman 6A. It provides for certain disputes of the nature of public utilities. It is defined under section 22A. It says 22B, public utility service means transport service for the carriage of passengers or goods by air, road, or water, postal, telegraph, telephone, supply of power, light, water, public system, public conservancy, sanitation, hospital service, insurance service. Any dispute, we call it as a pecuniary limit, any dispute up to 1 crore claim can be referred to Lok Adalat, and Lok Adalat can decide the dispute. Permanent Lok Adalat, PLA for short. Permanent Lok Adalat, PLA. I'll just give an example, you'll understand the whole thing. A patient gets admitted to a hospital, undergoes a treatment. He is charged, say, about 5 lakh rupees as his bill. He disputes the bill. He says, my charges are on the higher side. I would only give 2 lakh rupees, not 5 lakh rupees. So there is a dispute. We'll just examine this. So there is a serious dispute between the patient on one side and the hospital authorities on the other side, where the medical bill is a subject matter of the dispute. Maybe he also says, I'll give you the 5 lakh rupees under protest, but I will go to the court and claim this money. He gets discharged, comes back. He has a serious dispute where he issues a notice. So-and-so hospital, I was admitted to your hospital, blah, 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 blah. You have billed me so much. My bill ought to have been not more than 2 lakhs. Your bill is for 5 lakhs. These treatments are not required or appropriate, or you have charged me extra. I have paid you 5 lakhs under protest. Please give me back my 3 lakh rupees. The hospital says, no, our billing is perfect. You have been given all the treatment. You are entitled to, you are liable to pay 5 lakh. You have already paid. Therefore, we are not going to refund you. Do whatever you want. The dispute is created. Now, he has an option. He can go to the civil court. Okay, Ambu, tell me what are the options open to a patient now?
He can go for civil court or
Yes,
arbitration.
Good.
Or
the third one?
Here, sir.
Exactly. Exactly. You are right. See now the options opening up: civil court, arbitration, or Lok Adalat, permanent Lok Adalat. Permanent Lok Adalat is a body which is headed by a district judge, former district judge or a retired district judge, with a member who is also a court for the similar purpose. Please note, only in respect of these public utilities. In the event of a dispute, he can approach the public utility service, the permanent Lok Adalat, and try for getting the judgment. Same procedure, similar to a court case. He has to file some complaint. Notice will go. Opposite party hospital authority will appear. But the Lok Adalat, PLA, cannot straight away dispose of the case. The subject matter of the dispute is 3 lakh rupees, but it cannot straight away dispose of the case. First, the Lok Adalat, the PLA, has to try for a conciliation between the two parties, where both parties have to agree to negotiate between themselves. In the process of negotiation, if the hospital says, okay, I'll agree, but I'll give you concession of 1 lakh. The patient says, no, not 1 lakh, I want 3 lakhs or 2 lakhs. If the conciliation has failed, then only he can go for the disposal of the case and say, yes, the money which is paid by the patient to the hospital is more. Please refund the balance of 3 lakh rupees. Please note, he has to pass through the stage of conciliation where both parties try their best to conciliate, and the Lok Adalat also gives them the platform to conciliate. Try to see that both agree to agree. Agree to agree results in a conciliation, then it is over. Agree to agree doesn't happen, agree to disagree happens, then only he is empowered to go under section 22(8). What you have to read is 22(a), C, 7 and 8. I'm giving you the section because those sections are more important. I'm not saying that read only that, you have to read the entire thing. Similarly, other disputes. Can you give another example, Sweta? I told you telecom services.
Any education refund matter, something like
Perfect.
that, sir?
Perfect. Captation fee.
Yeah, refund.
Shweta joins some college, St. Joseph's Pre-University College, takes up science. They say, please donate to our institution. Shweta is forced to donate, but it is please. The word is please. So voluntarily donated by Shweta. Shweta gives 2 lakh rupees. This is in addition to the fees. After 1 week, even before the college starts, her friend tells her, "Ayo, Shweta, why did you join PCMB? You should have joined commerce. There is a lot of scope for commerce. Come to this college. There you would have been probably better off. PCMB is outdated." Now she has 2 minds. Ayo, I already made a mistake of depositing 2 lakh rupees. What do I do? She asked the principal for refund. She joins another college. Refund is not given. That can be a dispute. Have I answered you, Kweta? I think there's the same thing which you had in your mind. You can,
Yes.
now tell me which court could have you gone?
Direct option is Lok Adalat, permanent Lok Adalat has it as. Because if it is for a civil suit or something like that, that would take a longer process.
Correct. Any one more example before we go to the next part of it? I repeat.
I'm Kiran.
Yes, sir. Yes, sir. Kiran.
Can we actually take the example of something like a mediating company in between, which acts like a mediator between 2 parties, such as BookMyShow or Make My Trip, when we do the payment and then they don't return back. So if we have cancelled the trip and if they have not followed their policies, can we sue them?
What is the nature of service? Please note, permanent Lok Adalat says public utility service. It should be one among that. Otherwise, you can't go to PLA.
Sir, if I book for a trip to from Bangalore to Tamil Nadu through a
Yes.
government bus,
Yes, you can, because it comes
KSRTC.
under transport service. Kiran, have I replied you?
Yes, sir. Yes, sir. Yes,
The
sir.
public utility service, first one is transport service of the carriage of passengers or goods by air, road, or water. So it comes under that. Kiran, the best example is,
Okay, sir.
during the COVID. Please open your camera. I want to see you. During the COVID, so many people had booked their tickets to USA, UK, and so many other places. Suddenly, due to COVID, they could not go. The air agencies, they said, no, we will not refund you. Some people have gone to Supreme Court. Some people have gone to High Court. Some people have gone to so many other courts. Some people have also gone to Consumer Court. Probably the easiest, cheapest, and fastest would have been Lok Adalat, if it is less than 1 crore rupees. Shweta
Okay,
is
sir.
getting a lot of
Thank you,
ideas now. Oh, I made a mistake. Other day, I would have sent that case to Lok Adalat. See, this happens. Now you know that there are so many things which your client would have probably come to you, probably you would not have known. You would have told them, go to the civil court. Otherwise, it will, if you want, you wait for 10 years, you will get justice after 10 years. Lok Adalat, entry fee is 0. Certified copies, no cost. Judgment delivered to you or at your house. What else is required for you?
Sir, I had a clarification.
Yes, please, Naren.
Naren.
Yes.
See, basically, I'm running a 138 case for my personal thing. I'm running a 15 lakh check 138 before the fast track court in Kanyakumari, which is pending for the last almost 2 years. Due to COVID and not appointing a judge. Things have been happening over the period. So I'm just exploring two options. One is going before going for some civil recovery suit. Also, I'm trying to file, as well as criminal complaint. Also, I'm trying to do that. Is there any possibility under this particular thing? Is there any possibility for recovering the money?
Please note, once you have gone to the civil court, you can't come to Lok Adalat, permanent Lok Adalat. Please note, I'm not saying Lok Adalat, permanent Lok Adalat.
Okay.
I repeat, if you have already gone to magistrate court for recovery under 138, now
no,
you
138 is basically for it's not recovery. It's basically a criminal
criminal offense. I understand, but what is it you are looking for?
I'm
you are
looking for
recovery, or you are looking to punish him?
No, I'm looking for recovery.
So your main aim is to recover.
Yeah.
Not to punish him.
Yes.
If you had not gone to magistrate court, if it was a public utility service, you could have come to Lok Adalat, permanent Lok Adalat. Please note, the understanding is to be clear. If it is not public utility service, you can't come to Lok Adalat, PLA. If it is
it's a dispute. Service. Oh, it's a dispute between two individuals, right? That's what it's. There is no scope for
any two disputes will not be entertained in public Lok Adalat.
Okay.
It should be a public utility service like transport, postal. That's why I'm reading it again for your benefit. Transport service for the carriage of passengers or goods by air, road, or water. Postal, telegraph, or telephone service. Supply of power, light, or water to the public by any establishment. System of public conservancy or sanitation. Service in hospital or dispensary. Insurance service. There are one or two more because the amendment has been made. These only.
Okay. Understand.
Yeah. Secondly, your question has posed a very good debate. Once you go to Lok Adalat, you cannot come to civil court. Once you go to civil court, you can't go to Lok Adalat, permanent Lok Adalat.
But is it here my problem is concerned? Is there any mediation and is there any scope for recovery
that we'll discuss
money?
Tomorrow. That's the subject for tomorrow.
Okay. Thank you.
You have to hold on till tomorrow.
Yeah. Not a problem. Thank you.
Any other questions? Mr. Mahesh?
So another example is postpaid services for mobile services. For example, you go ahead and cancel postpaid, then they still go ahead and start billing you for, they don't want to lose you as a customer. That's something that I have encountered in the past. Did not know that I could go through permanent
Yes,
Lok Adalat.
you are right. This is a dispute which is probably fit under Lok Adalat, permanent Lok Adalat.
Thank you, sir.
I remember a case where a advocate known to me, a lady advocate, both husband and wife were advocates. They had deposited certain substantial amount in MIS scheme, monthly income scheme of the postal department. They had to shift because of the COVID. They had to shift to their native place from Bangalore. They went to the post office. They asked the transfer of the deposit. Firstly, there was no need to transfer remove the deposit. They could have transferred the deposit. They said, we want to remove the deposit. So please close the accounts, the MIS accounts. They said, okay. I think about 1 crore of rupees they had, and they sought for a refund of that. In the process, about 20,000 was deducted as bank charges. And the what do you call it? I call it something like that. Pre-closure. So bank charges 20,000 was asked. They never realized that it was 20,000. They went home, calculated, found that they had lost substantial amount. Then they said, we'll file a writ, we'll file that case, we'll file a civil case. Parties, they are going to their native place from Bangalore. Cause of action is in Bangalore. If they go to the native place, they are mainly going to native place because they want to avoid coming to Bangalore. But for this case, they have to come because it is cause of action in the Bangalore court. Then I said, why don't you try Lok Adalat, PLA? They filed it. In 3 sittings, they got their money. The deduction which was made by the postal department was wrong. They were supposed to collect only about 8,000 rupees. Instead, they had collected 20,000 rupees. They were made to pay the 12,000 rupees. They paid it. So any such examples, see, we are opening up to it. I can give you any number of some similar examples because I am also the advocate for Mahanagara Palike, BBMP. Public conservancy. We'll assume that there is a storm water drain going near my house, which is emanating mosquitoes. I could go to the High Court, file a public interest litigation. I can file a civil suit asking the Mahanagara Palike to take action. I can go to Lok Adalat and ask the same thing. If a party is aggrieved by the order of the Lok Adalat, then only directly writ. Otherwise, it is final, enforceable. Enforceability as good as a civil court case where it is enforced, namely Order 21 CPC execution. Yes, sir. This leaves me with another 15 minutes for Lok Adalat. Hitherto, I had discussed about permanent Lok Adalat. In the next 15 minutes, we'll discuss about Lok Adalat. So as I said, there is difference between Lok Adalat and permanent Lok Adalat. Lok Adalats are only camps. They are not a permanent body like permanent Lok Adalat. It is not a court like a permanent Lok Adalat. It's a camp where the member and the members of the judiciary or a legal fraternity sit in that camp. Cases which are already in the court are referred therein. The judges, the members sitting there officiate as members of the Lok Adalat, and they try to get the parties to consent and make them to agree for solution. Just recall what Mr. Trivikram told you. 10,000 cases disposed of, 80,000 cases disposed of. These are all cases which are already in the system, burdening the system. Maybe it is an insurance claim where there is an enhancement sought by for injury or for death in the accident, due to the accident. Or it could be 138 case. Mr. Narayan, I think, was saying his 138 case. He can also refer to Lok Adalat. So such cases which require not much of time, or it is less time consuming from the point of view of
But sir,
determination to arrive
but
at.
sir, what is the certainty of, see, if, say, let's say the what do you say, the other party, recovering the money is certain, or how does it, like, through
See,
Lok
Naren,
Adalat,
it
like
is
what
like
you were
this.
trying?
Your matter is already in the magistrate court. You can ask the
Okay.
judge to refer it to the Lok Adalat camp, not
Okay.
permanent Lok Adalat.
Okay.
The camps happen almost once a month, 3 months
Okay.
once.
Okay.
If that is referred and your opponent also comes there, through the intervention of the judge, who is sitting as a permanent, Lok Adalat member, if he is convinced and says, I don't mind paying Mr. Naren X rupees, and I would pay the same amount in 5 installments payable from today to December 2022. And Naren says, yes, I have no objection. That's a decree. That will
So,
be
but
drawn and that will be signed by both of you. And you will say that, yes, I accept rupees X. We'll just say your claim is for 10 lakhs. You are agreeing for 4 lakhs. I'm just giving an example. So as against my claim of 10 lakhs in the court, I will withdraw. 1 minute. I'll complete this. As against my claim of 10 lakhs in the 138 court, I am now agreeing to receive 4 lakhs in 1 lakh installment per month basis before December 2022, and he pays it in the equal monthly installments. If he doesn't pay me by 2022 December, your opponent agrees to undertake to give 10 lakh rupees on 1st of January 2023. This could be an agreement. That is as a decree. It is called as a decree of the court. Lok Adalat can sign the decree and give it to you. You also sign. By consent of the two parties, the both parties have agreed for a settlement, and that's a settlement. If it is not enforced, not followed, obeyed, you can go to the court and enforce it by filing a execution case.
Okay, so like recovery suit or something
exactly.
like that. Right?
Not a recovery suit, please note. It's not a recovery suit. Suit means again start afresh. No.
Okay.
You already have a decree.
Yeah.
Your case as if it is ended in a decree as the way you want it. That is called as a decree.
Okay.
That means to say the final verdict of the judge, which is final.
Okay.
That if it is not done, then there is something called as Order 21 in CPC, enforceability of the decree. There you can directly ask for his arrest, attachment of his properties, or call him to the court, ask him to pay the money, failing which the court can take severe action against him. That is called as enforceability. Execution, we call it in lawyers' terms. So your 138 case, which is pending in the court, probably it may take another 2 years, is referred to Lok Adalat, where both of you agree before a member to agree on certain amount and certain dates to pay it. Accordingly, both sign it. It becomes a decree, and that decree is enforceable decree.
Okay.
Again, it's nothing but the outsourcing of the dispute resolution by the judge, namely magistrate, to Lok Adalat, where they do the job of dispute resolution, make two parties to agree, and that dispute is agreed.
But I had always a liberty to say no to the settlement. See, something like which is I'm not.
You can walk in and walk out without settlement.
I understand.
You can walk in and say, I want 10 lakhs plus 10 lakhs. Please note your case is only for 10 lakhs, but you can say, I want 10 lakhs plus 10 lakhs. Otherwise, I'll not agree.
Correct.
If he says yes, that's an agreement. If he says yes, that is a decree. If he says no, you can walk back. It will come back again to the court and continue from where it had stopped.
Yeah, from where it stops. Okay.
Exactly.
Good. Thank you.
Just because you have referred the matter to Lok Adalat doesn't mean that you have agreed to compulsorily agree for a settlement. You can still say, no, I'm not agreeing. Or you can also agree for 1 lakh rupees, 10,000 rupees, whatever be your price, whatever be your amount.
Yeah.
Lok Adalat is very popular in India, as Trivikram put it. It is easing the burden on the judiciary substantially. Certain cases which do not require judicial adjudication or a serious judicial adjudication The judges take out those cases and refer to Lok Adalat, where they try to make the parties to understand, agree, but they cannot force, nor will they force. If the parties agree, the settlement is drawn, signed, the judges also sign, then it becomes as good as a decree of the court, and that decree is enforced if necessary by filing a execution petition under section order 21 CPC. Yes, sir.
Sir, in case if it is a
Any other question?
138, under the judgment, I was
Yes,
I
sir.
was prayed for two relief. One is giving maximum punishment, let's say whatever it is. The second one is give me compensation of 15 lakhs plus another 15 lakhs, 30
Yes.
lakhs. So in case I'm getting a decree on they are ordering give compensation 30 lakhs, that is a decree where I can again have a right to enforce, or so that is their right in 138 in the criminal CRP.
No, once you agree for recovery of the money, you lose your right to enforce it for criminal action.
Okay.
You can't have both.
Okay.
Suppose,
but
Naren, I was your opponent.
Yeah.
Naren, I'm just giving an example. I'm your opponent.
Yeah.
I agree to pay Naren 30 lakh rupees as a settlement in Lok Adalat. But if Naren says, no, I want you to be punished also, you have to go to the jail, I may say, no, I will not agree.
Okay.
So it's only upon both agreeing only it is possible.
Okay. Understand.
By consent. That's why we started this session saying that this is not for criminal disputes, but certain disputes which are criminal in nature, but actually quasi-civil, partly civil.
Like
the relief is
138,
given
right?
to you by way of a decree, not by way of a criminal order, criminal court order, arrest.
Okay.
I think that question of other gentlemen would ask is also answered. Some cases relating to matrimonial disputes, if it is related to a civil dispute, that criminal dispute also can be resolved through the civil dispute. Please note, though we started with the presumption or notion that ADRs are only meant for civil disputes, such disputes which emanate from a civil dispute also can be compounded and settled in ADRs. The best example is 138. Another example is 498A, domestic violence cases, because they are all attributable to a matrimonial dispute, which is a civil dispute. If the civil dispute is resolved, automatically along with that, the criminal dispute, which is a quasi-civil dispute, is also resolved. So it is 1 + 1. You take one, you get two. Buy one, get free. Two free. You resolve matrimonial dispute, 498A is also resolved. You resolve recovery, 138 is also closed. Yes, sir. We are left with 10 minutes. Any questions, Mr. Mahesh? Muted.
Sorry, I was muted. Sir, in your experience, do all civil suits go through some sort of, ADR?
Now, from 2002, it's a must. It's compulsory now. Not before. Earlier, it used to be only the advocates or the parties on their own attempting to do it. Now the judge is empowered to under section 89. And the law has become so simple or mandatory that every case of a civil in nature dispute has to be referred to ADR, any one of the ADRs, compulsorily.
Okay. Sir, also as a follow-up, have you, in your experience, seen judges basically negotiating during Lok Adalat? Because I've been through a few where basically our case was called and we were asked if the parties had settled, and there was at least one contesting defendant, and it wasn't, and it was just they kept aside. So the purpose of Lok Adalat is it for the judge to basically talk to both the sides, or do they expect that we do it outside and then walk in with some sort of a resolution that we all agree to?
It could be both. Sometimes the judges attempt, sometimes the parties would have already settled. Because parties settling by themselves, no judge would like to again take his time and try to explain. if it is settling but not reaching the finality, sometimes the judges intervene and say, why don't you settle, and try to convince the parties to settle. So it can be both. It can be both.
Thank you, sir.
Trivikram, you want to add anything? Dr. Mahesh? Trivikram?
Yes, sir.
By and large,
We are left with another 8 minutes.
Everything, sir.
Okay.
If we have any more questions, we will try to address it.
See, Dr. Mahesh, what I'm doing is I'm just giving the halwa and showing them.
Trailer.
Eat, they may smell it and keep quiet. Tomorrow, they can eat it and tell me whether they liked it or not.
Yes, sir. Yes.
Just introduce the concept. I'm not getting into the teaching method of yours where, you introduce a section, the purpose, the objective and all that. That is for the academic purpose. Here we are trying to understand the variety of things which are possible by just introducing the concept.
Yes,
what
sir.
is arbitration? What is Lok Adalat? What is the difference between that, and what is the advantage of this? What is the disadvantage of that?
Yes, sir. Yes, sir.
I am not answering all the questions which are required probably from an academic point of view as a lecturer or a professor. I'm trying to just give them the nuances of each one of them so that they start working on their own.
Yes, because Dr. Shobha Rani madam has extensively discussed on the provisions of the law, sir, on ADR.
Yes.
And we have a stimulation exercise too. And as per the university norms, this paper is for 100 marks.
Oh,
fully practical paper. It's a practical paper for them. So they has to do all these exercises and they has to attend all the programs and to submit reports too. Based on that, teacher will assess the marks. Report is submitted by the students, and the marks and the report submitted by the student is going to be assessed by the externals who are visiting the institution at the time of examination. So they are going to check the records as well as the marks given to. So they may increase the mark, they may reduce the marks. And finally, that marks has to be uploaded to the university. That's the process we are having, sir. So it is a mandatory for the students too. And moreover, it's a good area wherein which a student can learn more. Instead of a theory sitting in a class, they're exposed to practical aspects.
Yes.
Hand-on experience, learning through experiences.
Yes.
That's why Bar Council of India mandated that the legal education institution should have 4 practical papers. One such paper is ADR, and professional ethics we have a moot court too.
Okay.
So thanks for accepting our invitation. I don't know, sir, in what words I can explain my gratitude to the team. Entire team is working with us day and night, discussing about what to be done, what not to be done. On behalf of our Soundarya group of institution, on behalf of our Soundarya College of Law, I thank the whole team of members who are having a zeal to give something to the society, including my students too. So I also thank my coordinator, Shobha and Dr. Shobha Rani, who is instrumentality behind conducting this beautiful training session. Also thank to all my colleagues because they are my strength always. Also thank to students who actively participated in the program, and also thank to my IT team who dedicatedly working for the development of audiovisual content to upload into YouTube in upcoming days. Sir, once again, I thank all the person who are directly, indirectly responsible for conducting this beautiful one-day session in a 2 days training program. And also thank to my CEO, sir, and President, sir, and all the trust members for giving an opportunity to conduct this event. Tomorrow by sharp 10 o'clock, all the students be assembled in Ocarina. Be ready with all your doubts, whatever the questions which is not answered, which is not clear today. get it cleared tomorrow. Be actively participated in this event. Sir, we are eagerly waiting for your team to at 10:30 or the time possible, depending upon the situation. I request all the participants to reach on time. Then let us conduct the event in a systematic manner. And all the participants who are coming from a outside station, especially organizing team, you can get down at a metro station and you can call us either from me or to Dr. Shobha Rani madam. You can note down my phone number 8095727472. Let me to repeat 8095727472. Please come to metro station, give us a call. We'll try our best to arrange transportation facilities to reach the program in time. So I expect a good cooperation from the team and all the members for second day event also.
Dr. Mahesh, I have one idea. Since you said that all of them are assembling at 10,
yes,
and
sir.
we are coming from the session start from 10:30.
Yes, sir.
Till this time they are assembled and they are there. You can make them into 2 groups or 3 groups.
Okay, sir.
Ask them as to what is the difference between arbitration and Lok Adalat.
Done, sir.
3
arbitration
groups.
And
arbitration and Lok Adalat.
Lok Adalat. Okay.
1.
Okay,
Lok
sir.
Adalat and permanent Lok Adalat.
Okay, sir.
3rd, arbitration and court. 3 groups. Divide
Yeah,
them.
they need to discuss on this and to present some.
Just look, I mean, just discuss this.
Okay, sir. Done.
Once they again start, because we have covered this today.
Yes, sir.
So what they have understood from this, they will be probably discussing till 10:30. Once we come, we continue with the rest of it. Then we'll take up all their doubts and questions in the end.
Done. Done.
The idea is not just deliver and go. It has to be finally understood and implemented.
Yes.
Mr. Trivikram?
Vikram, sir, any suggestions, sir?
Sir has covered it all, sir. No suggestions at this point of time. Tomorrow we are also eager to meet you all in person.
Yes, sir. Hegde sir is in line?
I think so. No, I didn't see him now. Anyway, he's coming tomorrow.
Yeah. Yes, sir. Yes.
So those who are not from Soundarya, the institution of Soundarya, I think some of them are there. Shweta, Kiran, I already told. The option is open to you, Shweta. You can also participate because tomorrow is only physical. It can be directly coming to, metro. If you're coming in metro, you can directly come to Nagsandra. Be there by 9:45 sharp. Their vehicles will be there.
Sure.
We'll all go together. Come back by 4. Start by 4. Restart by 4.
Okay.
I think Savinay was there. Savinay, I don't know whether he's there now. Whoever is wanting to come, they can always come directly there. So I think that's it for today. We will meet tomorrow with more discussion. Thank you very much, sir. Thank you, Trivikram. Thank you, Dr. Mahesh.